sanctioning of resolution plan under the IBC. So I'm starting from what is the insolvency? A quick overview of the IBC code and its provisions so that we will reach to our main path, sanctioning of resolution plan. So this is insolvency means the inability of a person or corporation to pay their debts or bills, debts as when they are becomes due and payable. Bankruptcy means when he is declared incapable of paying their dues and bills. And liquidation means when the corporation is going to wind up completely. So these are the phases which can be faced by the individual or partnership firm or the company. Now, what is the preamble of the IBC? The preamble of the IBC to act to consolidate and amend the law relating to reorganization and insolvency resolution of the corporate persons, partnership firms, individuals in a time-bound manner for maximization of the value of the assets of such person, to promote the entrepreneurship, availability of the credits, balancing the interest of all the stakeholders, including the alteration, in order of the priority of the payment of the government dues, and to establish an IBBI for the matters connected therewith or incidental thereto. So this is the preamble. And what is the objective of IBC? Primary purpose of the IBC is to consolidate and streamline the insolvency law, expedite the resolution process, protect the creditors' interest, promote the entrepreneurships, and to revive the distressed companies. These are the basic objective of the IBC. These are the government regulator and adjudicator. The governing regulator is IBBI for insolvency professionals, insolvency professional agencies, and for information utilities. And adjudicators are the NCLT for corporate entities like companies and LLP. So we are going quickly through the provisions of the code. Section 4, applicability. The meaning ceiling minimum amount, minimum trigger is 1 crore rupees. Default amount 1 crore rupees for triggering insolvency resolution process. Section 6, person who may initiate the CIRP, where any corporate debtor committed default, then financial creditor, operational creditor, or the corporate debtor may initiate the CIRP in the respect of such corporate debtor in the manner provided under this chapter. Section 7, financial creditor either by himself or jointly jointly on behalf of financial creditor as notified by the central government may file the application for initiating the CIRP against the corporate debtor before the adjudicating authority. So I request to all of you that if you want to discuss or interrupt, you may please. I'm open and ready for the discussion. You may interrupt me whenever you feels like we need to discuss something. Section 8, demand notice. An operational creditor may, on the occurrence of the default, deliver a demand notice of unpaid operational creditor, copy of invoices demanding payment of the amount involved in the default to the corporate debtor in such form and manner as may be prescribed. Section 9, initiation of CIRP by the operational creditor. So where the operational creditor does not receive the payments within the reasonable time period or within the 10 days, then OC may file the application before the adjudicating authority. Section 10, initiation of CIRP by corporate applicant itself. So where a corporate debtor commits a default, a corporate applicant may file the application for the initiation of the insolvency resolution process with the adjudicating authority. But he need to take care that books of accounts are there, other documents are there. So it should be like special resolution should be passed by the shareholders. So it is a procedural requirement which should be complied by the corporate applicant before filing the application under Section 10. So these are the documentation criteria is very important for the admission of the application, because there should be a debt, there should be a default, but there should be the supporting documents and relevant documents which are proving the debt and default should be there. And when the company is going voluntarily, then the special resolution means approval of shareholder is required by 75% majority. Moratorium, as soon as the adjudicating authority admit the petition, then the moratorium period is applicable and the following actions are prohibited, like the institution of the suits or continuation of the pending suits or the proceedings against the CD, including execution of any judgment, decree, order in any court of law, tribunal, arbitration, or any other authority. Transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal rights or beneficial interest. CD is restricted to do this. Any action to foreclose, recover, or enforce any security created by the corporate debtor in the respect of its property, including any action under the SURFACE Act. And the recovery of any property by the owner or lessor where such property is occupied by or in possession of the corporate debtors. So these are the actions which are restricted for the corporate debtor in respect of CD. Section 16, appointment and tenure of IRP. The adjudicating authority shall appoint the IRP on the insolvency commencement date, where the application for the CIRP is made by the financial creditor or corporate debtor. The RP as proposed respectively, the application and whoever the RP or IRP is proposed, then will be appointed as IRP if no disciplinary proceedings are pending against him. And where the application for the CIRP is made by the operational creditor and no proposal for the IRP is made, then adjudicating authority, suo motu, will appoint any person, any insolvency professional as an IRP. And a proposal for an IRP is made. If a proposal is made, then he will be appointed. If any proposal is made for the appointment of particular insolvency professional as IRP, then he will be appointed as IRP if no disciplinary proceedings are pending. The board, within the 10 days of the receipt of the reference from the adjudicating authority, recommend the name of the insolvency professional. And the term of the IRP shall be continued till the date of appointment of RP under section 22. Section 17, management of the affairs of the corporate debtor by the IRP. From the date of the appointment of the IRP, the management of the affairs of the corporate debtor shall rest in the IRP. The powers of the board of directors or the partners of the corporate debtor shall stand suspended and exercised by IRP. Officers and managers of the corporate debtor shall report to IRP and provide the access to such documents and the records of the CD as may be required by the IRP. The powers are suspended, duties are not suspended. The financial institutions maintaining the accounts of the corporate debtor shall act on the instructions of the IRP in relation to such accounts and furnish all information of the CD available with them to the IRP. So, as soon as the CIRP is admitted, the IRP has a duty to send the communication to the financial institutions or bankers where the CD is having the bank account. And he may ask for the bank details and bank statements of the corporate debtor. And he is duty bound to provide all assistance to the IRP. IRP vested with the management of the corporate debtor. So act and execute in the name and on behalf of CD, all the act. So IRP has a power, IRP has a duty to take this access of the electronic records of the corporate debtor from the information utility, from the CD, from the personals, have the authority to access the books of accounts, records, and other relevant documents available with the government authorities also, statutory auditors, over accountants, and other persons as may be. So IRP may call the information from any person as may be specified. And very important, section 17, subsection 2 and subsection E, IRP will be responsible for complying with the requirements under any other law for the time being in the force on behalf of the corporate debtor. So if anything is not completed, which is required to be completed, which is required to be followed under any other law, like pending income tax return or pending ROC returns or pending deposition of the taxes, whatever. So he will be responsible for complying all the legal requirements under any other law, which is applicable under any other law for the time being in the force on behalf of CD. So this is the management of the affairs. And now section 18, duties of the IRP. The IRP shall perform the following duties: collect all the informations. So first of all, he will collect all the information relating to the assets, finance, operations of CD. So purpose of collecting this information is to determine what is the actual position of the corporate debtor. The information may be related to the business operations of the previous 2 years, financial and operational payments for the previous 2 years, list of the assets and liabilities as on the initiation date, and such other matters as may be specified. Receive and collect all the claims submitted by the creditors. So he will constitute the COC and monitor the assets of the CD and manage the operations until the RP is appointed by the COC. File the information. If IRP feels that this information should be filed in the information utility, then he may file as per section 18. And a very important task which is to be done by the IRP to take the control and custody of any assets over which the corporate debtor has an ownership right, which is recorded in the balance sheet also, or with information utility or the depository of the securities or any other registry that records the ownership of the assets, including assets over which the CD is having the ownership rights, which may be located in the foreign country, assets that may or may not be in the possession of the CD, then IRP has a right to have the ownership, have to take the possession of this property. Intangible assets, including intellectual property, securities, including shares held in the subsidiaries of the corporate debtor, financial, like he can control, he will take the control and custody of each type of the assets, whether it is tangible, whether it is intangible, whether it is not in possession of CD, where it can be in the form of securities, including any shares held in the subsidiaries or anywhere, or insurance policies, assets subject to the determination of the ownership by the court, and to perform any other duties which may be specified by the board. And which assets by a third part. For the purpose of this section, the term assets shall not include the following. Means we cannot take the custody and control of these assets, which is described in the ABC. Assets owned by the third party in possession of the CD held under any trust or under any contractual arrangements, including bailment, assets of any Indian or foreign subsidiaries of the corporate debtor, such other assets as may be notified by the central government. So these are excluded from the custody and control. Section 19, personals to extend the cooperation to the IRP. The personals of the corporate debtor, its promoters, or any other person associated with the management of the CD shall extend all the assistance and cooperation to the IRP as may be required. So personals means the promoters and any other person who is associated with the management. Where any personals of the corporate debtor, its promoters, or any other person required to assist or cooperate with IRP but does not assist or cooperate, then IRP may make the application to the adjudicating authority for the necessary directions. The adjudicating authority, on receiving an application under subsection 2, shall by an order direct such personals or any other person to comply with such instructions of the adjudicating authority. Section 20, management of the operations of the corporate debtor as a going concern. The IRP shall make the every endeavor to protect and preserve the value of the property of the CD and manage the operations of the CD as going concern. The IRP shall have the authority to appoint the accountants, legal and other professionals as may be necessary. He may enter into the contracts on behalf of CD or to amend or modify any contract or transaction which are entered into before the commencement of the CIRB. To raise the interim finance provided that no security interest shall be created over any encumbered property of the corporate debtor. So this is section 20 is speaks about like how to manage the operations of the CD. Means the actions which are necessary for managing the corporate debtor, for managing the day-to-day affairs, or for managing the effectively managed, so that everything should be in balance in terms of like professionals, in terms of like compliances, in terms of like day-to-day operations and all. So he can do this task like to raise the interim finance, provided that no security interest shall be created over any encumbered property of the corporate debtor without the prior consent of the creditors whose debt is secured over such encumbered property. Already, when any property is already encumbered with any other, any credit with any creditor, then again secondary security interest cannot be created over the property, provided that no prior consent of the creditor shall be required when the value of the property is less than the amount equivalent to the twice the amount of the debt. So this is the condition. To issue the instructions to the personals of the corporate debtor as may be necessary for keeping the corporate debtor as going concern. So in case of going concern entity, then the IRP has a power to issue the instructions to the personals of the corporate debtor as may be necessary for keeping the CD as going concern, and to take all such actions as are necessary to keep the CD as a going concern. Committee of creditors, the IRP shall, after collation of all the claims received against the corporate debtor and determination of the financial position of the corporate debtor, constitute the COC. So when the financial position is determined and claims are received, claims are verified, then IRP will constitute the COC, and which shall comprise all financial creditors of the corporate debtor whose claims are received and verified. Provided that a financial creditor or authorized representative of the financial creditor referred in subsection 6 or subsection 6A or subsection 5, if it is a related party, then shall not have any right of the representation or participation or voting in a meeting of the COC. Provided further that the first provision shall not apply to the financial creditor regulated by the financial institutions. So section 21 talks about the COC constitution. Section 22 talks about appointment of RP. The first meeting of the committee COC shall be held within the 7 days of the constitution of the COC. The committee of the creditor may, in the first meeting, by the majority vote of the not less than 66% of the voting shares of the financial creditor, either resolve to appoint IRP as a RP or replace the IRP by another RP. So where the COC resolved under subsection 2 to continue the IRP as a RP, then subject to written consent from the IRP It shall communicate its decisions to the IRP, the corporate debtor, and the adjudicating authority to continue the IRP. In case of continuation, IRP as RP, then it shall decision will be communicated to these authorities like CD and adjudicating authority and IRP. And in case of replacement of the IRP, it shall file the application before the adjudicating authority for the appointment of the proposed RP, along with the written consent form from the proposed RP in the specified form. The adjudicating authority shall forward the name of the RP to the board for its confirmation and shall make such appointment after the confirmation of the board. And where the board does not confirm, then direct the another person will be appointed as a RP. So this is section 22. Either IRP will be continue or the new RP will be appointed. For the appointment of the new RP, 66% of the voting share is required. Section 23, resolution professional to conduct the CIRP. Subject to section 27, the RP shall conduct the entire CIRP and manage the operations of the corporate debtor during the CIRP period. Provided that section 23, RP to conduct the CIRP, provided that the RP shall continue to manage the operations. This is not. Section 23 speaks about RP to conduct the CIRP, means the avoidance transaction application will not affect the conduct of RP. Then section 24, meeting of the committee. The members of the committee meeting may be meet in person or by the electronic means. So meeting can be held in both ways. Meeting is conducted by the RP. RP will give the notice of each meeting to the COC. The members of the committee of the creditors, including the authorized representative, members of the suspended board. So notice to whom? Notice to every member of COC, notice to suspended board, notice to OC, if their aggregate dues is not less than 10% of the total debt. So here the terminology is defined as a debt. So operational creditor, if the amount of their aggregate dues is not less than 10% of their debt. So the directors or the partners and the one representative of the operational creditors as referred to in subsection 3 may attend the meetings of the COC but shall not have a right to vote in such meeting. They can attend the meeting but do not have the right to vote, provided that the absence of any such direct or the partners or the representative of the OC as the case may be shall not invalidate the proceedings of such meeting. And subject to section 6A, 6B of section 21, who is the member of the COC may appoint any insolvency professional. So COC may appoint the insolvency professional to attend the meetings. Duties of the resolution professional. So what is the, after the, we have read the moratorium period, then appointment of IRP, then IRP may be replaced with another RP, then the role of RP is started, then IRP play his own role and he has some duties and powers which is to be done within the 30 days. And after 30 days, when the meeting is held, then either IRP shall continue or the new RP will be appointed. And now the second phase is the duties of the RP. So if new RP is not appointed, then IRP will be act as a deemed RP. And if the new RP is appointed, then he is having the following duty. So it shall be the duties of the RP to preserve and protect the interest assets of the corporate debtor, including the continued business operations. If there are the business operations continuing, then he will take care, he will preserve and he will protect the assets. For the purpose, RP shall undertake the following actions, namely, he may take the following actions like immediate custody and control of all the assets of the CD, including the business records, represent and act on behalf of the CD with the third parties, exercise the rights for the benefit of the CD in the judicial, quasi-judicial, or arbitration proceeding, raise the interim finance subject to the approval of COC. He may appoint the accountants, legals, and other professionals in the manner specified by the board. And he has a duty to maintain the updated list of the claims, to convene and attend all the meetings of the, prepare the information memorandum in accordance with section 29, invite the prospective resolution applicants who fulfill such criteria as may be laid down by him with the approval of the COC, having regard to the complexity and scale of the operations of the business of CD, and such other conditions as may be specified by the board to submit the resolution plans. These are the duties of the RP, which is defined in section 25. The main duty is 25H, to invite the PRA who fulfills such criteria as may be laid down by him with the approval of the COC, having regard to the complexity and scale of the business operations of the CD. So these are the, I have quickly gone through the provisions and sections which is mentioned in the code. And now I'm coming to the regulations, IBPI Insolvency Resolution Process for Corporate Persons Regulations 2016. So if members may want to discuss if anything which related to any topic, then please feel free to discuss. Or should I continue?
1 minute, madam. If you go to that 24 subsection 3, clause
Yes.
C, operational creditors are their representatives if the amount of their aggregate dues is not less than 10% of the debt. That
Yes.
means it is the total debt of the corporate debtor or the total debt of the particular class of operational creditors.
Yes. So the interpretation of this clause is like that. The operational creditor or their representative, if the amount of their aggregate dues is not less than 10% of the total debt. So we hereby refer the total debt of the CD. So if total debt of the CD, if we calculate and the OC is having more than 10%, then we will give the notice to them.
A particular OC, not
Yes,
together.
that particular OC. If that particular OC is having more than 10%, then we will serve the notice to him.
If I don't have, I will not be part of the meeting.
Sorry?
If we don't have that 10%, we will not be part of the meeting also.
Yeah, they will not be the part of the meeting, and we are not having any duty to serve the notice to that OC, because our committee is totally a committee of financial creditors, and if the debt is exceeds the 10%, then we have to give the notice to the OC. And any
One
director.
more thing, this IRP, while managing the CD, you go to section 20, part
Yes.
C, class
Yes.
C. To raise interim finance, provided that no security interest. See, for
Yes.
example, take the only to the extent of rising interim finance, and by that time COC is not created. Can he raise interim finance when there was no COC, or when he has to approach the AA for availing the interim finance?
So there is a provision to raise the interim finance, but security interest cannot be created.
Yeah, that is true. But if you go to the section 28, I think
20?
there 28. There are certain A to M clauses in which interim finance, if it is to be taken, it is to be taken with the approval of the COC.
Yes, it can be taken.
But here, when IRP has not yet constituted the COC, how can he raise interim finance?
So he may source outside, no? He may source outside
He
to
may,
take the interim finance.
no, he can raise interim finance without approval of anyone.
He will take the proposition from third party to raise the interim finance, but he need to take the approval from the COC to raise the interim finance.
Yeah, that is true, madam, but COC is not yet formed.
COC is not found, then it cannot be approved.
Then why
IRP or RP has to
why
constitute
it
the
has come
COC.
here? That is my doubt.
No, he
Why
has
it
to
is part
constitute
of
the...
IRP's duties when IRP cannot on his own raise an interim finance?
Yeah, he cannot do its own. It requires the approval of the COC. As per section 28, if you will go.
No, that is true, madam. But see, once the COC is formed, RP will come.
Yes.
So
Sir,
RP will take. But IRP, how can he run the CD? And on the other side, he wants to raise the interim finance when there was no COC.
I understand your question, sir, but my view is that IRP run the corporate debtor for whom? For COC. For balancing the interest of the stakeholders, for maximizing the value of the creditors, and for the recovery ultimately. So if IRP, if he is taking these important decisions to raise the interim finance and like that, for which the section 28 is incorporated, and you are saying that he cannot do its own. So absolutely he cannot do its own. He is running the CIRP. If he want to, he has to constitute the COC, and then he need to take the approval. If he is It cannot be happen like that. He is in hurry and he want to manage the CD, so he will take the decision at its own. So he has to comply the requirement of the
Yeah.
IBC.
Hmm.
So he has to follow the proper procedure.
Or otherwise, only when there is the security is sufficient, twice the amount of the debt, then he can raise the interim finance. Is there any such, privilege to the IRP before constituting the COC? That's why it is given in section 20 before constituting COC.
But it is required the approval of COC. There are so many actions which can be taken by the IRP. There are so many actions, but some actions require the approval of COC. Because the section 20 talks about, section 20 speaks about the how to manage
IRP.
how to manage and what to manage.
How to manage by the IRP.
How to manage and what to manage. And what he can do to protect the interest of CD, to protect the interest of stakeholders. So there are so many points which the IRP has a power to do, but his power is limited to some extent, and he need to take the approval. He cannot contravene the provisions, and he cannot take the decision at its own, so that he cannot say that I'm taking this action to protect the interest of the creditors. It's not like that. There is a provision which IRP or RP need to follow. So in practical scenario, we can't go like this. This is written in section 20. I can raise the interim finance. And so we have to read the act or the code in holistic way. And after reading and understanding in the holistic way, we will implement the provisions. Because this is the role of the IRP. He cannot go like even in the NCLT orders, the adjudicating authority direct the IRP or RP to do this, but he has to take care of the provisions of the code also while performing the duties.
Now I understand this clause in two ways. One is that if the property value is twice the value of the debt, the residual value of the property
Yes.
is twice the amount of the debt, IRP with the approval of the same creditor can rise. Or second thing is that the IRP, if he continues beyond the even after constitution of COC and till the appointment of RP, then he will, if he wants to raise finance, he has to take the COC.
Yes, because there is a conditional. This is condition provided that no prior consent of the creditor shall be required where the value of property. So sir, value of property निकालने के लिए registered valuer को appoint करना पड़ेगा. And registered valuer appoint होता है 47th day पे. तो उससे पहले आपकी COC हो जाएगी, ठीक है. But as per law, if we are reading this line now, then provided that no prior consent of the creditor where the value of such property is not less than the amount equivalent to twice the amount of the debt. Like 100 रुपए का डेट है और प्रॉपर्टी की वैल्यू अगर 200 रुपए से ज्यादा है, तो then we don't need to take the approval of the COC. But in prudent practice, we can do. But in prudent practice, we should inform to COC before taking this decision, because it is again investing. Because again, any creditor is investing the money into the CD. It's
Madam,
like
this 22C, that is only for an individual creditor who is having a security, not for the COC. COC is a combination of all creditors.
Say for a particular financial creditor providing against particular security, and if there is a residual value more than the debt he can raise, then he need not take the permission of the creditor. But
the COC's permission is required, not the individual creditors.
I think there might not be many case where the IRP raising interim finance.
No. In my case, IRP raised the interim finance.
Then he obtained the permission.
But the value of the interim finance is more than this condition. So the COC approval is taken.
After a constitution of
forms
COC,
only after.
Sorry?
COC will be formed only after RP is appointed. Where is the question of IRP when COC is formed?
No.
IRP can be a deemed RP pending the appointment.
IRP or RP's role is almost similar. In case of protecting the interest of the investors, in case of protecting the interest of the stakeholders, then he may take the decision after the approval of the COC. IRP or RP doesn't matter. Because IRP will perform the role of RP until the appointment of the RP.
And then COC will come into picture, no issue.
COC will
But-
come into the picture because it is very important decision to take. Even if the condition, because in 99% case, this condition is not fulfilled, like the value of the property is not less than the amount equivalent to the twice. There can be any scenario like that. So it's better to it's better to take the informed call, because if we, suppose we are doing this as per the provisions and as per this proviso, which is mentioned here, and thereafter the COC asks the question, you raise the interim finance. In practical scenario, I'm saying that you raise the interim finance without the permission, then it create the difficulty to convey. It create difficulty like that ki
Convince
why
the
you,
COC.
yeah.
And I think
For what purpose you have
can,
taken? For what
in
purpose?
case of in case of emergency, IRP can raise this interim finance
Yes.
subject to the ratification of the COC.
Yes. Yeah, this can be happen. This can be happen.
But
This
this
can
can be
be.
form part of CIRP cost.
Yeah, this will be part of the CIRP cost. Yes, absolutely.
Yes.
Interim finance is also it's coming into the my next slides. I have covered one or two or more provisions into this. Anything else need to be discussed?
Yeah, I'll go to regulations.
So section, if you see 28(1)(a).
Yeah. Yeah.
In my slide, it is also there, I think. Okay, just a minute. 28(1)(a).
Raise interim finance in excess of the amount as may be
Yes,
decided by the
yes.
committee of creditors in their meeting.
Yes, 28(1)(a) makes it clear. So notwithstanding anything contained in any other law for the time being in the force, the RP during the CIRP shall not take any of the following action without the prior approval of the COC. To raise the interim finance in the excess of the amount as may be decided by the COC in their meeting. So this is related to that section.
No. This is something like, suppose a COC says that it is a 40 lakhs is to be raised in interim finance. He cannot take
It
beyond
also
40
related.
lakhs.
It is
He
also
cannot take
related. Yeah. But, it also speaks about. It is saying that suppose COC is saying that 500 rupees is enough for raising the interim finance. And if IRP thinks that it's not sufficient and it requires some more amount for the raising the interim
Then he
finance,
has
then
to
66% approval is required. COC's 66% approval is required to raise the interim finance as per this section 28(1).
Yeah. And suppose interim finance is thought of IRP, RP, thinks of taking rising interim finance, then he will put up an application to the COC that this much is required for running the CD. Then
Yes.
that will be approved. Beyond that, he cannot take. If he wants to take beyond that amount, he has to take invariably the approval of the COC.
COC can also give the interim finance to the CD. COC can also provide.
Yeah.
COC can also provide the interim finance.
Yes.
This CIRP cost, which is
Generally, it will not happen because already they have invested.
No,
it is
no.
only it is only for new investors.
But there is a provision, so they can provide at the rate of interest whatever they want. Like it's
I
depending.
think even the prospective resolution applicant can also give finance.
So IRP or RP can raise the interim finance from the third party also, from COC also, and where the rate of interest is lower than he can decide appropriately.
And the CIRP cost, which is contributed by the COC members, does it amount to interim finance?
No, it's not interim finance. CIRP cost is different, interim finance is different. The utilization of the interim finance will be
For activities.
will be done by the IRP in payment of the cost as well as for the production activities and all. What for the Because IRP has to explain where the amount will be utilized before raising the interim finance. Where the
No,
amount
the
will be utilized.
my point is the money which is coming from the COC members, it is in the form of interim finance or it's a contribution.
Interim finance agreement will be executed. Interim finance agreement will be executed.
Because in the liquidation process regulation, there is a provision that if they contribute something towards liquidation cost, the financial creditors will have to be paid some interest on that. So no such provision is there in the CIRP
No.
regulation.
2A.
In liquidation, which regulation?
No, it's not that. If the contribution is delayed, then those have
If the
to pay interest.
contributors to this liquidation cost, if they have made
2A,
some
madam, 2A, I
contribution,
think.
so they have to be paid
Liquidation
interest
rules.
on that.
No. You are talking which section?
No.
It is under
I
the
think
liquidation process regulations.
No.
Regulations. So there is, which regulation can you tell me?
Just
Regulation 2A, I think, madam.
yeah.
Regulation 2A.
No.
That is different.
No, that is different. But he is
That is
saying
different.
if that under CARP, if it is not decided, the creditors will contribute, and if they do not pay that, then they have to pay interest.
No, if the contributors contribute toward the liquidation cost,
Yeah,
so
it is.
they will have to be paid interest at the prevailing bank rate. That is the provision. It is at 2A3.
The amount contributed under sub-regulation 2 shall be repayable with the interest at the bank rate referred to in section 49 of the RBI Act. So it is saying about 282. The contributions made under the plan approved under sub-regulation 3 of regulation 39B or the contributions made as the case may be shall be deposited into the designated escrow account to be opened and maintained in a scheduled bank. The contributions made under the plan approved. So CIRP, it's talking about when in the CIRP, when the plan is approved and the money shall be deposited in a designated escrow account to be opened and maintained in a scheduled bank within the 7 days of the passing of the liquidation order.
Did not approve a plan.
Yeah. And the amount contributed under subsection 2 shall be repayable with interest.
So it's sort of a interest paid for the contribution made toward the liquidation cost by the financial
Then it is
creditors.
applicable. Yeah, then it is applicable.
So here in CIRP, there is no such provision. Even if they contribute toward the liquidation CIRP cost, they are
There is
not
no
paying
such
it.
provision like that which is into the liquidation regulations, which is mentioned in.
So the same thing that 2A3, that is for compensating the financial creditors for contributing to the liquidation cost.
So there in the CIRP, like it's not similar provision. There is this in the CIRP when the interim finance is raised, it is raised upon certain cost, upon certain interest. So the interest will be payable to the interim service provider, interim finance provider. So who is providing the interim finance? That interest rate will be provided to them. So this provision which is mentioned in the liquidation regulation is not similar likewise in the CIRP.
It is not there. So that's the sort of a, because many financial creditors don't
This
contribute
interest rate is negotiable.
The
Sorry?
CIRP cost, many
interim
COC
finance
members don't
raised.
contribute also because they don't get anything in return. That is the practical difficulty.
It is the practical difficulty. Yes, it arises in case of liquidation. In the CIRP, though mainly in case of going concern unit, the interim finance is needed. Otherwise, it's not needed.
No, the CIRP cost which has to be borne by the IRP or RP,
Which
the
is
valuation cost, CIRP fees, etc. So that is a part of CIRP cost. So that has to be contributed by the COC members if the CD doesn't have any cash flow.
so it has to be paid by the COC. It has to be, if it is approved by COC, it has to be paid later on after the approval of the resolution plan. It will be reimbursed.
Yeah, in theory it is fine, but practically it becomes difficult when the number of COC members is large.
Large, and generally they resist to contribute.
Yeah.
It is a practical difficulty which is facing by the every IRP and RP to realize the cost.
Yeah.
So can we proceed?
Yeah, yeah.
So we are. We are coming to the regulations. Quick review of these regulations. Regulation 2A. Record or evidence of default by the financial creditor. So at the time of filing this application, section 7 application, so what are the documents which is required to be annexed with the petition? So for the purpose of the clause A of subsection 3 of section 7, the financial creditor may furnish any of the following records or evidence of the default, namely certified copies of the entries in the relevant accounts in the banker's book, and by an order of the court or tribunal that has adjudicated upon the non-payment of the debt where the period of the appeal against such expired. So these are the information, records or evidence of the default should be attached. Regulation 2B, records or evidence of the transaction debt and default by OC. So in case section 9 application, so what are the documents which is required to be annexed with section 9 petition for filing before Honorable NCLT? Like in supporting document, we can file the GSTR1, GSTR3B, which is relating to the goods and service tax, and the copy of e-way bill wherever applicable. So these are the documents which can prove your debt and default. Provide the provisions shall not apply to those OC who do not require the GST number, not covered under the GST. Regulation 2C. The financial creditor or the operational creditor shall, while filing the application under section 7 or 9, as the case may be, also furnish the details of its permanent account number and email ID. This is the basic requirement. Regulation 2D, details of the debt, default and limitation in the respect of the application under section 7 or section 9. While filing an application under section 7 or 9, the financial creditor or the operational creditor, as the case may be, shall also submit along with evidence chronology of the debt and debt default, including the date when the debt becomes due, date of default, dates of the part payments, if any, date of the last acknowledgement. So this is the part of the petition which is to be submitted at the time of filing application, like the chronology of the debt, when it is occurred, default kab hua, date of default, dates of part payments, if any, and the last date of the acknowledgement of the debt and the limitation, which is to be provided to advocate for filing these applications.
No role of RP in this area. IRP.
No role of IRP or RP. He may suggest to advocate what to file or what do's and don'ts, and वैसे तो advocate better knows. But being a IRP or RP or upcoming IRP or RP, अगर हमने consent दी है, तो we can suggest कि these documents are required to be annexed. Regulation 3A, assistance and cooperations by the persons of the corporate debtor. The IRP or the RP, as the case may be, shall take the custody and control is specified under this regulation from the persons of the CD, its promoters, or any other person associated with the management of the CD, as the case may be, the records of the information relating to the assets, finance, operations of the CD, referred in the clause A of section 18, and such other information required under regulation 36. The assets recorded in the balance sheet of the CD or in any other records which is referred in section 18F. The persons of the corporate debtor, its promoters, or any other person associated with the management of the CD shall provide to the IRP or the RP, as the case may be, a list of the assets, records while handing over their custody and control, and the IRP or the RP may, taking such control if deemed necessary, identify the persons in whose possession these assets and records will be held. Where any assets or records has not been handed over or list has not been provided, so it's better to take the list of the assets from the management or from the suspended management or from the personals. So where any assets or records has not been handed over or list has not been provided, the IRP or the RP, as the case may be, shall himself prepare the list of the assets and records while taking the custody and control of the assets. So what he has taken and what he has not taken, what is provided, what is not provided, like that. So he may prepare the list, and it will be the very sensitive record at the time of taking the custody and control. Each list of the assets and the records under the subregulation 2 and 3 shall be signed by the parties present and by at least 2 individuals who have witnessed to act. So this is the statutory requirement: 2 individuals who witnessed of taking control and custody. The IRP or the RP, as the case may be, shall request from the personals of the corporate debtor, its promoters, or any person associated with the management of the CD, the information relating to such assets, finance, and operations of the CD referred in the clause A of section 18, and such information required under regulation 36, which are required to be maintained by the corporate debtor but have not yet been handed over. The IRP or the RP, as the case may be, shall request the personals, promoters, or any person associated with the CD, as the case may be, the assets which are recorded in the balance sheet and जिसका custody अभी नहीं दिया है but record which is showing in the balance sheet, but you have not taken the custody, then you may request the suspended board, suspended directors to have the details and to request to take the custody and control. An application, if he is not supporting, then obviously we may file the section 19 application if he fails to provide the assets or records of the assets. So we are having these powers also. IRP or RP, as the case may be, may access the books of accounts, records, and other relevant documents and information to the extent relevant for the discharging his duty. So we are having the power to take the information from like depositories, professional advisors say, and information utilities say we can obtain the details. We can obtain the details, records of ownership from the registries and all, like sub-registrar office and all. Members, promoters, partners, BOD, joint venture partners, and any contractual counterparties. So we may, any person who is connected with the CD, then we can call the information. The personals of the corporate debtors, its promoters, or any person associated with the management, then they are the duty bound to provide the confirmation to the RP or RP in the time bound manner. The creditor shall provide to the IRP or the RP, as the case may be, the information in the respect of the assets and liabilities of the CD from the last valuation report. So this is like that कि जो creditor है, जो भी the creditor shall provide means यहाँ पे bankers, whatever, whoever, the last valuation report, stock statement, receivable statement, inspection reports of the property, whatever he is having in his possession, like audit report, stock audit report, title search report, technical officer report, बैंक अकाउंट स्टेटमेंट, यहाँ पे मैक्सिमम टर्मिनोलॉजी यूज की गई है कि whatever they are having such information which will assist, which may assist, because IRP or RP has to know the present status of the CD and he has to prepare the information memorandum. So he need these details. So he may obtain these information from the creditors at the time of the preparing the information memorandum and to get the present financial position of the CD. Regulation 4C process email ID, obviously at the time of commencement or at the time of getting order, as soon as we get the order, then we will create a new email ID, process email ID, and for specifically for the CIRP or liquidation or what CIRP when at the time of, and then we will hand over this email ID if in case of replacement and all. So RP in case of, so all the communications will be made from this email ID. This is called process email ID. Regulation 6 public announcements, which is to be done by the IRP within the 3 days, Form A, and in the 2 languages, and where the registered office is situated, and where the business operations are going on. Regulation 6A, communication to the creditors. The IRP shall send the communication along with a copy of public announcement made under Regulation 6 to all the creditors as per the available books of accounts of the corporate debtor. So it is the duty of the IRP or RP is that any creditor is showing in the balance sheet, then we has a duty to send a communication to file the claims so that he will get intimated about initiation of the CIRP and he will know that this claim needs to be submitted. So it's the duty to send a communication. It's our duty to send the communication, public copy of public announcements, and also that he will do the needful for the submission of the claims. And claims by the OC. So OC, if any operational director connected with corporate debtor, he may file the claims with the proof in the Form B. The existence of the debt due to the OC under this regulation may be proved on the basis of the records available with information, utility, other relevant documents, including the contract for the supply of the goods. But as a IRP or RP, our duty is what? If anybody is filing the claim, like he may be the OC, he may be the FC, we have to check these documents which is required under the law, which is required to be submitted by them. So we have a duty to take the decision to verify the claim on the basis of these documents. If anything is missing, then we can call the additional information from the creditors. So this is their duty to submit this document, and our duty is to verify on the basis of these documents. In case of missing documents, we may always call for additional information. So OC may submit the records. This is the important records which is available with information utility, if any. On that basis, IRP or RP may take the decision for admission or rejection of the claim. Other relevant document also work, like any invoice, contracts, order of court, financial accounts, books of accounts में वो debt आ रहा है, copy of relevant extracts of GSTR1 or GSTR3. So on that basis, IRP or RP may decide to admit or reject the claims.
Madam, if this CD's records are not available for cross-checking, so shall we go by what is there in the
But yeah, it is cross-checking, but we have to check everything before admission or rejection of claim.
But then you have to only depend on what the creditor is submitting along with his claim.
But as IRP or IRP, if I am receiving it's not sufficient to check the claim form only.
No, along with claim, he will submit the invoice or whatever bank statement he is having.
We need to be satisfied. We need to be satisfied. If I am admitting the claim, then you have to satisfy me.
No, but there is no data available with the CD for cross-checking. In that case,
Yeah, in that case, I'm not saying that. I'm saying that, yeah, if anything, like in most cases, what happened? The balance sheet is not filed from last 3 years. The financial statements and all, it is not filed from the last 3 year, 4 year. But the latest, what we are having right now, then we can look into that. And not only the CD's document, the creditor who is providing the document on that basis, obviously, agar usne loan diya hai, to he is having the document so that he is filing the claim. So we will verify that document.
financial creditors, sufficient sources are available to cross-check, but for operational creditors,
For example, operational creditors, if he is submitting the claim, he is giving me the invoice, okay? So invoice. So I also need to cross ledger copies. So I will call the ledger copies. If he is claiming that my 100 rupees to be admitted with 15 rupees interest, then what is the proof of the admitting interest? How I can admit the interest of the rupees 15? So I will need the supporting documents. So where is the contract where you have agreed or that party is agreed for the interest? So I will not admit that interest without the document, without any document or that. So as a IRP or RP, because in case of, it's depend upon case to case. If it is a closed entity, then it's different scenario. If it is a going concern entity, then I have received the more than 50 claims of the OC, which I have verified. But I have to take the uniform decision for all the operational creditors. So if one OC is saying that I have charged 10% interest, another is saying that I have charged 12%, another is saying that I have charged 15% interest. So I have to be uniform for all the OCs. So I need to careful. So what is the standard document which I need to verify for all? Like obviously I have to check the invoice. Without invoice, I'm not going to admit. Or in case of going concern, if he is not having any invoice, but in my record, in CD's record, it is showing as a debt, then I will admit. So it's your discretion on what basis, on what uniform because in future I may need to prove on what basis I have admitted this claim and I have rejected this claim. So
yeah, where the corporate data is available, it is easy to do the cross-checking. If it is not available, then it becomes.
If it is not available, then I'm depend upon the creditor that he will provide me the document and he will satisfy me, because it's my duty to verify the claim very properly. In case, specifically in that case, when I don't have any document of the CD.
Because if the debt due to the operational creditor is more than 3 year old, straight away we can reject his claim, saying it's time barred.
Yeah, we can reject. Yes. If it is time barred claim, then we can reject. But we are not. We are talking like for the documents. So
you can ask this creditor to show that the debt is within the time limit.
We have to verify that.
No, because we don't know whether the CD has admitted the debt and it is a continuing debt.
No, sir. In case when any OC is filing the claim, then he will attach the invoice copies. So we will verify the date of invoice and all, ledger copies and all. We will verify everything, na? So if we are seeing that this claim is like 2015 ka koi invoice hai, then we have to verify that it is time barred. It cannot be claimed, so we cannot admit. So we have to verify all the document. That's why we are calling for the additional information. So there is a particular clause. IRP or RP may call for the additional information and substantiate.
Yeah, we'll
to
mention in the list of creditors. We'll mention it in the list of creditors and we'll mention the reason why you are not
because I have
admitting
to,
that.
because he is having the duty to substantiate and I have a duty to call the information. So I have to upload these claims on the IBBI website also. So IBBI, if IBBI will verify these claims or IBBI, so is a governing body, he can call for any record, na, anytime. So I have to maintain for 8 years all the records. So it's my duty. On what basis, actually on what basis I am accepting or rejecting the claim. I cannot simply admit or reject on.
Many IPs mention in the list of creditors that claims are under verification because you can't finalize the decision till the list of creditors is made out. So what is the sanctity of that note that it is under verification?
So you are asking that I'm mentioning under if I will write under verification when I have called the information, he is not provided within the timeline, then I will reject the claim.
So maybe you will need some time to verify whatever documents he has submitted, and
then I will keep it under verification. Because within 7 days I have to verify the claim, and if there is any case where I need some more time, then I will keep it as under verification and like reason for under verification. Because this is claim verification is very like every process, every step is sensitive वैसे तो CIRP में, but I need to maintain the records why I am on what basis I am taking such decisions. Because any creditor can file the interlocutory application against the IRP or the RP or on any ground कि why I have not accepted or rejected any claim, any claim.
You must be very careful also while rejecting it.
Sorry, I will not listen.
No, when we are going to reject it, we should be very careful also.
Very careful,
Because
and we have to mention the particular case laws or what is the particular reason.
give the reasons also why you are
Even
rejecting.
reasons on what basis we are rejecting, because we will reject on the basis of some like provisions of the code or on the basis of some judgment and all, because we cannot reject on any sufficient cause should be there, sufficient cause for the rejection of the claim or admission of the claims. So our duty is to call the information. If he is not providing, then he is not fulfilling his work or he is not able to substantiate his claim, then it's their fault. We cannot हम हमारी डिग्री या हम हमारा ड्यूटीज को खराब नहीं कर सकते because of non furnishing of the documents. So we maintain the proper records. Why we have admitted the claim, how we have admitted the claim, and how the amount is calculated. We usually call the Excel sheet also. We usually call ki you have arrived that amount. So please provide the Excel sheet of the calculation, how you have arrived this amount, principal and interest, how you have arrived. We want to verify it. So please provide the Excel sheet of that, because in some cases there are so many invoices. Like बड़ी-बड़ी 2-3 files आती है, तो there are the like 500 invoices like that. So we can't verify the each invoice and we cannot so we call the Excel file so that we give the proper files so that soft copies so that we can verify your records. We can verify your claim properly. So
If IRP can hire the
I know,
professional to do the
I
verification
know.
of claim.
Yeah, I know, but because it's a for fast track check, we generally if we can call the any information for our convenience or for our verification. So we generally call. If they don't give, we have to do. So it's a general practice to call from everyone. These are the set of the document which is required. In case, okay, Excel sheet is not mandatory document, I can't force you. But if we are calling the information, then we can add on that this information is required for the substantial. And if creditors को ऐसा है कि मेरा claim accept होना चाहिए, तो he always provide the information.
This IRP can engage a chartered accountant to do the verification.
Yeah, but again, when we think about cost, COC always resist to approve the cost. So we always try to reduce the cost. We always try to reduce the cost as we can. Like, and we should, because already there are going to be so much substantial haircuts. So we always try to reduce the cost to not to expand wherever it is not necessary. Because these factors COC को तो ऐसा है कि 5,000 में भी like 5,000 में भी बार्गेनिंग के लिए COC मीटिंग में 10-10 15-15 मिनट वो लगा देते हैं 5,000 की बार्गेनिंग के लिए. they invest 10 to 15 minutes for rupees 5,000. So we always try to reduce the cost. Like claims by the financial creditors. A person claiming to be a financial creditor other than a financial creditor belonging to a class of the creditor shall submit the claims with a proof to the IRP in the electronic form in the form C. So ऐसा भी होता है कि कभी कभी प्रॉपर फॉर्मेट में प्रॉपर फॉर्म में नहीं होता है ये क्लेम फॉर्म. तो we request to provide the particular claim form and submit your claim in this prescribed format, which is prescribed by the IBC in IBC regulation. So we generally send the format if anybody is not having. We assist the claimants to file the claim properly. And the existence of the debt due to the OC may be proved on the basis of the records available with information utility, other relevant documents, including a financial contract supported by the financial statement as evidence of the debt, a record evidencing that the amount committed by the financial creditor, financial statement. So these are the documents which is required to be annexed with the sections claiming while filing the claims by the financial creditors, so that the claim can be substantiated on their part. Regulation 8A, claims by the creditors in class. So there can be the class creditors like home buyers, fixed deposit holders, and anybody can file. Any who is falling in this category, then he can file the claim. The existence of the debt due to a creditor in a class may be proved on the basis of the records available with the information utility or letter of allotment, receipt of payment, any document, whatever they are having, they can submit and claim the money. Regulation 10, substantiation of the claim. IRP or RP may call other informations or evidences for the substantiation of the claims. Regulation 12, submission of proof of claim. A creditor shall submit the claim with the proof on or before the last date mentioned in the public announcement, provided that a creditor who fails to submit the claim with the proof within the time stipulated in the public announcement may submit his claim with proof to the IRP or the RP as the case may be up to the date of the issue of RFRP or 90 days, whichever is later. So the claim can be filed up to 90 days or up to the date of issue of RFRP, which is required to be issued under regulation 36B, whichever is later. Provided further that the creditor should provide the reason for delay in submitting the claim beyond the period of the 90 days. So we will also look at the reasons for the delay. What is the reason behind so the reason is very important. So financial creditor must provide the reasons for filing the delayed claims. So where the creditor in sub-regulation 1 is a financial creditor under regulation 8, it shall be included in the committee from the date of the admission of the claim. Okay. And provided that such inclusion shall not affect the validity of any decision. Verification of the claim, the IRP or the RP as the case may be shall verify every claim as on the insolvency commencement date within the 7 days from the last date of the receipt of the claim, and thereupon maintain a list of the creditors containing the name of the creditors along with the amount claimed by them. The amount, we will verify everything, like what is the amount claimed, what is the security interest, they are secured, unsecured, and whether where the IRP or the RP as the case may be does not collate the claim after verification, he shall provide the reasons for the same. And regulation 13(1)B says that in the event that claims are received after the period specified under sub-regulation 1 of 12 and up to the 7 days before the date of the meeting of the creditors for the voting on the resolution plan or the initiation of liquidation, then as the case may be, the IRP or the RP as the case may be shall verify all such claims and categorize them as acceptable or non-acceptable for collation. So after after the specified period, if the claims are submitted up to the 7 days of the meeting for the for voting on the resolution plan or the initiation of the liquidation up to that, then what is the duty of the IRP? What is the duty of RP? That he will verify the claims and categorize them. If it is acceptable or not. So he will not admitting or rejecting. He is only forming an opinion.
The difference between collation and verification?
Like collation here simply means in one of my case. So यहाँ पे RP is not admitting. He is just collating the information and forming the opinion. In one of the case, one of the creditor, Punjab National Bank, has submitted the claim just before the meeting of COC meeting where the resolution plan is going to be approved. So what we have done, we have just collated the information and form an opinion whether it is acceptable or non-acceptable. This is only the duty under this regulation, verification. We are not admitting or rejecting it, we are keeping it as it is. And we have done our work, verified that claim. Because
once you verify and put it in the list of creditors, then it becomes an admitted claim. No?
No, in this case, it is mentioned that we are coming into 1C, the IRP or the RP as the case may be. Yeah. Next clause is 1C. We are reading that section. So 1B is we are verifying the claim, and 1C is the IRP or the RP as the case may be shall intimate the creditor within the 7 days of categorization thereof under sub-regulation 1B and provide the reason where such claim has been categorized as non-acceptable for collation and put the claims categorized as acceptable and collated by him to the committee in its next meeting for its recommendation for the inclusion in the list of the creditors and its treatment in the resolution plan if any, and submit such claim before adjudicating authority for condonation of the delay and adjudication wherever required. So this makes it clear. Regulation 1C. So first step is we are verifying the claim, acceptable, non-acceptable. Then we are informing to COC, and then we are discussing in the COC. And within the 7 days, we can take the decision in the COC meeting, what the COC suggests. So it's totally depend upon in practical scenario, it is totally depend upon the reason of delay. The COC will take the decision on the basis of reason of delay. Because if I'm IRP or RP now, then I will categorize for acceptable or non-acceptable. So my view is depend upon reason of delay. So generally in most of the cases it is non-acceptable because from the initiation of the CIRP and till the approval of till the 150th day you are coming to submit the claim, then what will be the reasonable what will be the reasonable course? I think there will not be any reasonable course. So in most of the cases, the reason of the delay is considered. So if there is a proper reasonable delay or whatever reason can be, so on that basis, I will form the opinion, I will present to COC and the COC will decide.
Acceptance or rejection of the claim, that is the authority of IRP or RP.
COC, because I in this case, the IRP or the RP shall intimating the creditor within the 7 days of the categorization and provide the reasons where the claim has been categorized as a non-acceptable and acceptable. So this is clearly
this is for the belated claims, I think. Not for
yes. Because in the committee will because ultimately what happen, ये जो delayed claim आ रहा है ना, तो वो क्लेम आ रहा है ताकि उन्हें रिजोल्यूशन प्लान में जो पैसा ऑफर किया जा रहा है उसमें उनको चाहिए पार्ट चाहिए, तो सीओसी नेवर एग्री कि ये जो लास्ट मोमेंट पे क्लेम आया है कि हम उनको पैसा क्यों दे रिजोल्यूशन प्लान में से, ठीक है, तो ठीक है वो सीओसी का डिसीजन है, डिपेंड अपॉन केस टू केस. सो देयर विल बी 2 सिनेरियो. तो या तो सीओसी उसको एडमिट कर लेगी और प्लान में हिस्सा देना पड़ेगा व्हाटएवर रिजोल्यूशन प्लान इज गोइंग टू बी अप्रूव्ड. लेकिन सेकंड सिनेरियो में क्या होगा कि अगर obviously IRP को तो पता ही है कि what is going to be happen in this case. So if claim is not admitted, if claim is categorized as a non-acceptable, then he can make the claim in liquidation. If resolution plan is not going to be approved, then IRP or RP may suggest to claim in liquidation. Because in liquidation, fresh list of SEC will be, fresh list of the stakeholders will be prepared. And if it resolution plan is going to be approved, then he may file the IA in the NCLT for the condonation of delay.
So till the NCLT gives the order for accepting or rejecting this claim, your resolution plan process
Plan will
gets
be
stuck.
delayed,
Yes.
will be delayed because there is a IA filed by some claimants. So it जब तक वो solve नहीं होगा, then adjudicating authority will never allow the approval of the resolution plan because there are ongoing litigation तो and related to claim. So he has to take the order from NCLT. Ultimately, in practical scenario, this happens that he has to go to NCLT and take the direction.
Now, RP has to go to NCLT or the claimant has to go?
इसमें nothing is clarified. इसमें ऐसा होगा, इसमें practically हमने क्या किया था, we have rejected the claim. ठीक है, COC के approval के बाद we have rejected the claim. तो reject होने के बाद why we will go to NCLT? So we will not go to NCLT. Claimant will go to NCLT. Because we have totally rejected. Because we have wrote that your reason is not viable and feasible, and it's not sufficient cause to filing delayed claim. So we are rejecting your claim, and that's is तरह से हमने legal reply दिया, and then we are
So on the
rejecting.
ground of delay only it will be rejected, not on the merits.
Reasons. Delay ka reason he have to provide the reason as per 1A sub-regulation 1A where the IRP or RDA SPK does not call it 1A नहीं, वहाँ पे एक point था कि he has to give the reasons for the submitting delayed claims. So if the reason is not sufficient, reason is not feasible, then after the approval of the COC, we will reject the claim, and then he may go to NCLT for admission of claim belated claims. इन दिस केस इस 1C में ऐसा भी हो सकता है, एक सिनेरियो ऐसा भी हो सकता है कि IRP और RP उसे एडमिट करना चाह रहा है, मींस उसने ऐसा कैटेगराइज किया है कि इट इज एडमिशेबल बट COC इज रिजेक्टिंग, देन RP में गो टू NCLT फॉर एक्सेप्टेंस ऑफ दिस क्लेम फॉर द कंडोनेशन ऑफ द डीले. बट जनरली प्रैक्टिकल सिनेरियो में ऐसा होता नहीं है. जो क्लेम सबमिट कर रहा है क्लेमेंट्स विल गो टू NCLT फॉर कंडोनेशन ऑफ द डीले. Practically, otherwise it is possible कि RP may go to adjudicating authority or claimant may go to it, because in most of the cases when we reject, अभी ये provision तो अभी आया है like कि claim can be submitted up to the date of the RFRP. इससे पहले जब ये provision नहीं था और 90 days के अंदर किसी ने claim नहीं किया था and he is filing delayed claim means beyond 90 days, then we straight away reject the claim, then he go to NCLT for the acceptance for the admission of the belated claim. So same is here.
Yeah.
If same applicable is here. So if he is submitting the delayed claims, even after providing these itna timeline देने के बाद भी he is coming at this stage, then simply we will reject the claim and he will go to NCLT for seeking the directions.
Okay.
So this is the regulation 16. Regulation 16, committee with only operational creditors. So when there are the no financial debt or all the financial creditors are related party of the corporate debtor, then committee shall consist 18 largest operational creditors, one representative elected by workman, one representative by employee. Voting will be done in the proportion of the debt and same rights of the COC. Same, they will have the same rights as COC. Regulation 17, Constitution of COC. Related party of the CD will not be the part of the COC, and IRP or the RP will file the report certifying the constitution of COC. Regulation 18, meeting of committee. The first meeting will be within 30 days. It can be called when the at least 33% voting rights members request to the RP or IRP, and the main important agenda items needs to be discussed in the first COC meetings. then regulation 19, not less than 5 days notice. We can reduce this notice by the COC's approval. So not less than first notice is not less than 5 days notice. It can be given by the hand delivery or by the post or by the electronic means. Regulation 20, service of notice by the electronic means, we can do so. And contents of the notice, this is practical in practical scenario. This is very important because sometimes the content of the notice are not sufficient and COC take the benefit of that notice. And generally we mention that please attend those members only who are having the who are competent and authorized to take the decision on spot, because generally COC what did they do? They do give, we will discuss with our competent authorities and we will discuss with internal committees and then we will decide and we will require more time, and the CIRP timeline is very short and we are unable to perform the duty within the timeline. So we generally mention the important contents that please clear intimation that the person who is attending the meeting should have the authority to decide upon the voting agenda items. And regulation 24, conduct of the meeting. RP shall act as a chairman of the meeting. RP shall take the roll call, ascertain the quorum, prepare the minutes, circulate the minutes within the 48 hours of the meeting to the FC and suspended management. Quorum should be at least 33% of the voting rights should be present throughout the meeting, not in middle of the meeting, like if anybody is going, it should not be done. Quorum of the meeting should be present throughout the meeting. Regulation 25, voting by committee. So there are some agendas which require the 66% majority of the COC. So if any agenda which we are going to propose for the voting items, then we can propose the COC to vote by raise of hands, vote by voice or vote by e-voting. Then voting sheet will be prepared and voting window shall be open for at least 24 hours to 7 days. Regulation 27, appointment of professionals. So we are having the duty to appoint the two registered valuers to determine the fair value and liquidation value. Any professional, accountant, transaction auditor, GST consultant, we may appoint any professional which we are having the need of it to assist in discharge of the duties in the conduct of the CIRP on arm's length basis. Regulation 30, assistance of the local district administration. IRP or RP may make the application to the adjudicating authority for seeking the assistance of the local. So if generally ये जो regulation 30 है वो कब काम आता है? कस्टडी और कंट्रोल लेने के वक्त जब हमें किसी की जरूरत होती है, when we are anticipating that promoter may create some nuisance or may create some problem, then we can take the assistance of the local district administration. Regulation 30, withdrawal of application. RP may make the application to adjudicating authority for the withdrawal of the CIRP if COC approve this agenda with a 90% voting share. Regulation 28, transfer of the debt due to creditors. In the event a creditor assign or transfer the debt due to such creditor. So in ऐसा भी हुआ है एक केस में कि CIRP को 3 months complete हो गए and then एक creditor ने अपना debt किसी और को transfer कर दिया ARC को. So in this scenario, what happened? हमारा COC constitution change हो जाएगा, हमारा list of creditor change हो जाता है उस केस में. So in the event a creditor assign or transfer the debt due to such creditors, in ongoing CIRP की बात कर रही हूँ, during the insolvency resolution period, then both parties shall within 7 days of such assignment or transfer provide the IRP or the RP as the case may be, the terms of such assignment or the transfer and identity of the assignee and transferee. And RP shall notify each participant and adjudicating authority of any resultant change within the 2 days, which is very short period. 2 दिन के अंदर हमें ये भी पता नहीं चलता है कि कौन असाइनर है और कौन असाइनी है और क्या टर्म्स पे असाइन किया है, कितना असाइन किया है, क्या वोटिंग राइट चेंज होगा, हमें कुछ पता नहीं चलता. एंड विद इन 2 days हमें रिकॉन्स्टिट्यूशन करना पड़ता है. सो वी हैव टू नोटिफाई विद इन 2 days ऑफ सच चेंज. सो दिस इज रेगुलेशन 28. So anything to be discussed? This is regulatory fees, regulation 31A. A regulatory fee calculated at the rate of the 0.25% of the realizable value to the creditor under the resolution plan approved under section 31 shall be payable to the board where such realizable value is more than the liquidation value. So ये regulatory fees कब applicable होगा? When I have highlighted that when under the resolution plan is approved under section 31. Then it shall be payable to the board where the realizable value is more than liquidation value, provided that the sub-regulation shall be applicable where the resolution plan is approved after 1st October 2022. A regulatory fee calculated at the rate of the 1% of the cost being booked in the insolvency resolution process cost in respect of hiring any professionals or other services by the IRP or the RP as the case may be for assistance in a CIRP shall be payable to the board in the manner 1% of cost booked in the respect of hiring of any professional. It shall be payable to the board. Regulation 33 and 34. So IRP or RP cost, the COC shall fix and approve the expenses incurred by the IRP or the RP. The expenses shall be at the CRP cost. Cost shall be disclosed to the IBBI. And 34B. 34B.
0.25% is to be paid by successful
0.25% to be paid to IBBI.
by the resolution applicant.
Yes. No, RP.
But from which source it will come?
RA will give. Because at the time of, if he is putting the resolution plan of the 1 crore, then we will say that 0.25% you have to give the extra.
It's only after the plan is approved, no?
Yeah, when adjudicating authority approve the plan, then only we have to pay to the IBBI. There is a, when we log in into IBBI portal, then there is a icon where we have to fill the details and we have to pay the regulatory fees. So provision should be there in the resolution plan, so that we will intimate to PRA about this fees and in the his terms जो भी वो financial offer करता है या what are the clauses जो भी होते हैं resolution plan में, he has to mention this clause particularly कि ये जो इन्होंने plan दिया है, it is excluding this fees, including this fees, or it will be payable separately on actual basis or whatever. So he has to mention this clause because it is a duty of RP to pay. So we should inform to RA. He may not aware about this. Fees to be paid to the IRP. And 34B, performance linked incentive scheme, where the resolution plan is submitted to the adjudicating within the time period, then performance linked incentive may be given to the RP. I have not mentioned the table here, but there is a timeline. If we are completing the CIRP within this timeline, then we will be rewarded through this scheme.
Yeah, it is.
Only with the COC's approval is required for that. It's
yes,
not automatic.
Obviously, because it is a part of CIRP cost now. It is a part of performance linked scheme is also the part of the CIRP cost. So it is to be approved by COC and then the RA will pay. So it's the discretion of the COC. It's not duty bound. It
is decided at what point of time, when the RP is appointed or when the plan is approved?
No, this performance linked scheme, when the plan is approved by the adjudicating authority, similar, likewise regulatory fees.
No. COC at what point of time should consider this?
At the time of approval of resolution plan. This is the incidental agenda of approval of resolution plan, because we are approving the resolution plan within the 150 days, for example. Then we will put this agenda also to approve this scheme.
The initial appointment itself, this can be part of the condition of the RP's appointment. That
sorry, didn't get your point.
When the RP is appointed at that point of time, also this
No. This is the last stage. This is the last meeting. COC last meeting.
No, COC is the terms of appointment of RP. This can be one of the clause that along with your the normal fees. This will be
there is no need to clause because it is mentioned in regulation.
But at that point of time, COC may not agree after everything has been done.
So if we are having the licensing with COC member, then we pay because it is very uncertain कि PRA कितने आएंगे और plan कब approve होगा और होगा या नहीं होगा कितने का bid लगेगा. It's not certain. It's not planned. It's not planned.
Yes, it will be easy to get it approved because that time COC will be interested in getting better realization from the resolution.
So
So
it's,
they may agree for giving incentive initially, but once the plan is approved, they know that hey, money is coming now. So
if we are doing everything honestly, and if we are doing very like promptly, then their moral duty, it's their moral duty to do this, to at least, because it's not going from their pocket, na. It's not going from their pocket. Their stake will not be reduced.
no, this CRP cost means that will be going from their cash flow only.
It
na?
is approved by them, but it is ultimately payable by PRA, no?
Okay, in the ultimate
Ah,
end, this
yeah.
will be paid by the
That is
resolution applicant. Yeah.
Yeah, that is resolution applicant will pay, but yeah, their stake, their some portion will be reduced.
Yeah.
But it generally very rare cases I have seen that, and there is no clarity in the provisions also कि they must approve or मतलब like उसमें may लिखा हुआ है may COC may approve, तो there is not like compulsory.
Discretion.
It's a discretion. मतलब it's not like कि so it's create confusion actually. It creates like COC meeting में थोड़ा it creates like ऐसा scenario बन जाता है COC के लिए भी और RP के लिए मांगना मतलब it's not statutory right to say कि ये हमें चाहिए. So we can submit a request. It's a requesting like proposal कि we can make because it's discretion कि वो कितना भी कर सकते हैं. इसमें तो ऐसा percentage भी है कि 0.65% or whatever we can claim, but it depends upon the discretionary power of the COC that वो कितना करते हैं like 0.12%, 13%, 60%, 0.50%, whatever they decides. This is the minimum fee structure prescribed for the IRP or the RP, and similar we adopt this minimum fee structure for the personal insolvency resolution also because there is no minimum fees is prescribed. So we mutatis mutandis we apply into other procedure also. Regulation 35, fair value and liquidation value. The registered valuer shall submit the RP after the physical verification of the inventory and fixed assets of the CD. If two assets are significantly different, then we may appoint third valuer. Means 25% से ज़्यादा का difference आता है, तो we can appoint another third valuer. 35A, preferential transaction, where RP has to determine that any preferential transaction has taken place up to 150th day. RP shall apply to adjudicating authority for appropriate relief. He may file the application of avoidance transaction. Now, this is very important regulation, information memorandum, which is very critical document for PRA because ultimately the object of this resolution is the object of the CIRP process is to make the resolution. So this resolution ultimately will be done by the third party, will be PRA, and if the PRA is aware of everything, what is into the CD, what is the value of actual value of the CD, then we have to take care while preparing the information memorandum. It's a detailed and comprehensive document which is to be shared with each member of the COC on or before 95th day of the insolvency commencement date, and which is having very vast, which is not having, which we should incorporate very sufficient information or significant information about the operations of the CD, financial statements of the CD, and there are some clauses, clause by clause, where we should have to put the information. But in practical scenarios, what PRA want actually, what PRA want to know, he want to know mainly the assets. He want to know mainly the assets. What are the assets and what are the litigations pending? So he is concerned about two things because he know that all the liability will be extinguished ultimately. Okay, but he need to fight with litigations. Okay, he need to fight or he need to something to he has to do with litigation, and he will make the bid on the basis of available assets. So what is the assets and what are the ownership rights available and what he will get? So these are the clauses. Subject to the regulation 4, the RP shall submit the information memorandum in the electronic form to each member of the committee on or before 95th day of the insolvency commencement date. The IM shall highlight the key selling propositions and contain all the relevant information which serve as a comprehensive document conveying the significant information about the CD, including the operations, financial statements to the PRA, and shall contain the following informations of the corporate debtor. So, सबसे like clause number 2A says that assets and liabilities with including contingent liabilities with such description as on ICD as are generally necessary for ascertaining their values. And description includes such as a date machinery है या कुछ है तो date of acquisition, cost of acquisition, remaining useful life, depreciation charged, book value and all, where it is belongs, location क्या है, where it is, the latest annual financial statements, audited financial statements of the CD for the last 2 financial year, जिससे कि वो so that he can ascertain the financial position, and a list of the creditors containing the name of the creditor, the amount claimed by them, what is the liabilities, मतलब वो कितना किसको offer करे, so you have to we have to clarify the list of the creditors, secured FC, unsecured FC, and operational creditors, operational maybe who is secured, who is unsecured, government dues and all. Particulars of a debt due from or to corporate debtor with respect to related parties, details of the guarantee that have been given in relation to the debt of the CD, the name and address of the member or partner holding at least one. So, in case of very simple private limited company, these are available, and this is very easy to capture the information from different sources. The details of all material litigations and ongoing investigations or proceedings initiated by the government or statutory authorities, subject to the information provided by the CD. The CD has to provide all this information. We have to take the custody and control. At the time of taking custody and control, we have to collect these details actually. Without these details, we can't prepare and form this information memorandum. The number of the workers and employees, liabilities, any gratuity, PF spending or whatever. Company overview, including the snapshot of the business performance, key contracts, key investments. If company has made their investment, there is a contract which is signed by the corporate debtor. Other factors which bring out on the value as a going concern over and above the assets of the CD, such as brought forward losses in the income tax returns and input tax of the GST, key employees, carry forward losses. So this is very exhaustive document which we have to prepare very carefully so that the PRA will get all the information about the corporate debtor before submission of the resolution plan. Fair value. So COC may decide not to disclose the fair value. Other information which the RP deems relevant to the committee. A member of the committee may request the RP for further information or the nature described in this regulation, and the RP shall provide all such information to all the members within the reasonable time if the information has bearing on the resolution plan. The creditors shall provide to the RP the latest financial statements and other relevant information of the corporate debtor available with them. The RP shall share the information memorandum after receiving the undertaking. This is the statutory requirement that we have to take the undertaking from the COC members before sharing information memorandum या कोई भी sensitive document like valuation reports, transaction audit reports. So we should take the undertaking from the COC, confidential undertaking. So before sharing any document. So this document is a very exhaustive and comprehensive document. So we need to take the details from the CD, from creditors, from any other sources, from where we can. Can we have 5 minutes small break? Anjali,
We will come back.
yes, 5 minutes, only 5 minutes. So we were at this information memorandum. So this is very exhaustive document which is to be prepared very carefully, and we always try to incorporate each and every detail related to corporate debtor to facilitate the PRA so that he can wisely make a bid for the acquisition of the corporate debtor. And regulation 36A, inviting for the expression of interest. RP shall publish the Form G in the newspaper to invite the PRAs submitted to IBPI website of the CD, if any, contains last date of the submitting expression of interest. So this is the Form G, which is having the prescribed format and detailed invitation. So this is the process memorandum, a detailed EOI we can say. So RP has a duty to determine the eligibility criteria after the permission of the COC with the approval of the COC, which specify the criteria for the PRAs as approved by the COC, state the ineligibility norms of section 29A, basic information about the corporate debtor. So what is the main eligibility criteria which needs the approval of COC? So what net worth criteria? So we will decide the net worth criteria for the individual before the submission of the bid. Like we may discuss with the COC that what should be the minimum net worth criteria for the individual, for the partnership firm, for the consortium, and for the private limited company, for the public limited company, for the partnership firm, for the LLP. So we need to discuss the eligibility criteria for, because if any bidder is participating in the resolution plan submission process, then we have to fix a minimum net worth criteria so that below the net worth criteria, nobody can make the submission of nobody can participate in the resolution plan. We don't want that everyone is participating for just for expressing the interest, just for wasting our time. So we need to very wisely need to fix the net worth criteria with the discussion with COC members. So besides that, we will mention the undertakings, about some undertakings like 29A undertaking, affidavits, necessary affidavits, and along with the detailed EOI, which is to be submitted by the PRA for submission of bid in the corporate debtor. Inviting for the expression of interest. So when we are into this regulation 36A, so RP fix the minimum net worth criteria, and then PRA submit the bid for the acquisition of the corporate debtor. And then when we receive the bids, when we receive the eligibility documents from the PRA, then we has a duty to make the proper due diligence of the prospective resolution applicant. And we have a duty to check the section if he is eligible in section 29A or not. RP may seek the additional information or clarification from the PRA. And then we have to make a provisional list. So provisional list we will prepare within the 10 days from the last date of the submission of the EOI, and which will be shared to the COC members and prospective resolution applicants. So we will include those PRA into the provisional list which are fulfilling that eligibility norms, which we have decided, like net worth criteria and turnover criteria and all. So if they are fulfilling, if they are eligible in that criteria, then we will include in the provisional list. And objections, if any RA or PRA is having any objection, then he may raise within 5 days. And final list, RP shall issue the final list of the PRA to the COC within the 10 days. Regulation 36B, request for resolution plan. So this is RFRP document, which is also very, very exhaustive document. This is to be prepared by the RP, and it is to be shared with the PRA. So this is the information which contains the details about what is the process and manner of the submission of resolution plan. So this is request for resolution plan to be prepared to be shared within the 5 days from the date of the issue of the provisional list as per the applicable timelines. The request for the resolution plan shall allow the PRA minimum 30 days. So RP will provide at least 30 days to the PRA for providing the resolution plan. Along with it will have the various provisions which are required to be made, like to provide the performance securities after the approval of plan by the COC. And the performance securities jo bhi hogi will be forfeited if the resolution applicant after its approval fails to implement the plan. RP, with the approval of the committee, may extend the timelines for the submission of the resolution plan. So basically, this document covers the process of submission of the resolution plan and criteria and what is the procedure and manner of forfeiting your performance security, when the plan will be approved, when the EMD will be refunded, when you cannot back out, when you can when you can out, and whatever the applicable provisions to be mentioned in RFRP. What is the amount of EMD, earnest money deposit you have to deposit with the resolution plan? What will be the performance guarantee that will be deposited with the resolution plan? So there are the terms and conditions which is applicable for the PRA who is going to submit the resolution plan for the acquisition of the corporate debtor. So basically, these are the index I have prepared, which is required to be mentioned in the RFRP document. So generally, what we mention for facilitating the PRA, so that he can get aware how to submit the resolution plan, because as a layman we prepare so that if anybody want to submit the resolution plan, then he can prepare based on this document. So what are the information to be contained in this document? So first, participation process, how to participate. So we mentioned the definitions, general abbreviations, which is mentioned in the IBC codes. So to facilitate the PRA, for the better understanding, we mentioned the definition and there what is the definition of the particular terminology. Resolution plan process for submitting resolution plan by the PRA. So what will be the process so that you can submit the bid? We explain the process, we explain the manner of submission of resolution plan. Examination and evaluation of resolution plan. So we mentioned that we will examine your resolution plan and we will evaluate, and commercial wisdom of the COC will be there while evaluating the resolution plan. So we mentioned the provisions relating to that evaluation. Amendment to the invitation for the resolution plan. We will also mention that we may amend this document after the approval of the COC so that the PRA will, if any updates are received, if RP received any update from the COC or whatever, then we reserve the right to amend the RFRP, this document. Like again, Form G is issued, then it will be amended. The document will be amended. So it depends. Timeline will be changed. In case timeline will be changed, then again this document will be dependent. So we reserve the right to amend this document. Right to verify the resolution plan. Then we also mentioned that how the plan will be verified, and right to disqualify and accept or reject any or all. So we also mentioned that you cannot question why we are accepting or rejecting any resolution plan. So we may, the commercial wisdom is there, and we may make our own due diligence, and based on our due diligence, we may accept or reject the resolution plan. If any clarifications is needed, then we mention the clarification for the PRA so that future litigations and future joby litigations and can be avoided. So we mention the proper clarifications for the sake of clarity. Preparation and submission of resolution plan. So in that clause, we mentioned that you have to prepare the plan and the cost will be borne by you, and you have to submit the plan within this deadline, and along with soft copy, hard copy, pen drive, password protected, whatever. We mentioned the manner of submission and where you have to submit the plan, and what are the documents which need to be submitted, what is the EMD. So we mentioned the proper procedure. Earnest money deposited, we mentioned clearly about the EMD to be deposited with the resolution plan. So this document should be should clearly describe the procedure and manner of submitting resolution plan so that any person after reading this document can do the needful for submission of plan. We also mentioned the performance guarantee. About the performance guarantee clause, we mentioned that you have to deposit the performance guarantee amount after the plan approval by the COC. Binding plan due date, what will be the binding plan due date, and you will be bound by the plan if it is approved. And schedule of the resolution plan process, we mentioned that timelines, that this timeline may it will happen, this will happen, this timeline we will provide this data room to you, this timeline we will submit the resolution plan to adjudicating authority and all. Terms and conditions for the participation, we mentioned in this clause that the basic terms and conditions which you will be abide by this process. So we mentioned the terms and conditions of this participation, and what like in how many days the EMD will be refunded in case of rejection of resolution plan, how many days, like the interest, whatever, what are other terms and conditions we mentioned in this clause. And mandatory contents of the resolution plans. So this is very important clause. As per regulation 38, we already mentioned that what are the important clauses which you have to mention in the resolution plan. so that PRA cannot say ki you have not informed about the mandatory contents of the resolution plan. So as per provision, we mentioned that. Other essential requirement, we mentioned that you need to disclose this, you need to incorporate this disclosures and confidentiality agreement. So these are the clauses basically we mentioned in the RFRP document for the PRA, so that he can submit the better resolution plan in better way, in legal way, so that it can be considered by the COC. So if it will follow the proper process, then there will be the rare chance of the modification in the resolution plan. So we also attach the format of appendix annexures. I have mentioned in my slide that we give these formats to the PRA for the submission, along with the submission of the resolution plan, so that he has to attach these documents with the resolution plan, like basis for evaluation criteria, evaluation metrics, that is called contained of resolution plan. So these are the appendix which is required to be apexed with the resolution plan by the PRA. Without that, the plan will not be considered, because it contains the various like affidavits, undertakings, financial proposals, board resolutions, confidential undertakings, and all checklist provisions. So these are the appendix annexures. We give the format with the RFRP document itself for the convenience of the PRA, so that he can take the proper informed call and submit in the proper manner to the RP. Regulation 37 resolution plan. The resolution plan shall provide for the measures. So PRA is going to submit the plan. PRA is going to submit the plan, though हमारा ऑब्जेक्टिव ऐसा है IRP और RP का कि whatever will come, it should be for the benefit of maximization of the value of its assets. Means we have to give the maximum amount to the FC, OCs and all. So what can be provided in the resolution plan? What can be? So it can have the provisions of, like, the resolution plan may provide the different kinds of plan, different kinds of measures to revive the corporate debtor. So he can offer like this, that transfer of all or part of the assets of the corporate debtor to one or more persons, sale of all or any part of the assets, whether subject to any security interest or not, restructuring of the corporate debtor by the way of the merger amalgamation, he may offer like this. The substantial acquisition of the shares of the corporate debtor, or the merger or the consolidation of the CD with one or more persons, he is going to do. Cancellation or delisting of the shares if he is going to do. Satisfaction of security interest, curing or waiving any breach of the terms of any debt, and reduction in the amount payable to the creditors. Extension of a maturity date or a change in the interest rate or other terms. Amendment to the constitutional document of the corporate debtor he is going to do. So he can do like that. Issuance of the securities of the corporate debtor for the cash, property, securities, or exchange for the claims or interest or other appropriate purposes. Change in the portfolio of the goods or services produced or rendered by the CD. Change in the technology used by the CD. Obtaining the necessary approvals, license from the CG or SG. Sale of the one or more assets of the CD to the one or more successful resolution applicant, submitting the resolution plan for such assets in the manner of the retaining the assets. So resolution plan may provide these measures. Regulation 38, mandatory contents of the resolution plan. So we mentioned this clause in the RFRP document for better perspective, for giving better perspective to PRA, so that he will formulate the plan accordingly. So these are the mandatory content. As a IRP, being a RP, I need to check whether these mandatory contents are incorporated in the resolution plan or not, because ultimately we are going, our main topic is for what are the determinative aspects of sanctioning of the resolution plan. So now coming to that topic, what are the determinative aspects? But means the factors upon which the approval is depends by the adjudicating authority. As a RP, we need to check that whether these provisions are contained in the plan or not. So Regulation 38 deals with the amount payable under a resolution plan to the OC shall be paid in the priority over the FC. To the amount payable under a resolution plan to the FC who have a right to vote but did not vote in favor of the resolution plan, then shall be paid in the priority over the FC who voted in favor. A resolution plan shall include a statement how it has been dealt with the interest of all the stakeholders, including financial creditors and operational creditors of the corporate debtor. So it should include a statement ki how he has treated to FC and OC. Resolution plan shall provide a term of the plan, what will be the tenure, what will be the implementation schedule, the management and control of the business of the CD during its term, like how he will manage the business of the CD and how he will supervise its implementation, resolution plan, and manner in respect in which the proceedings in the respect of the avoidance transaction will be pursued after the approval of the resolution plan, and the manner in which the proceedings will be distributed. So this point is very important, like any avoidance application is filed by the RP. If any avoidance application is filed by the RP, then as a PRA, you should mention that you will pursue that application or COC member will pursue this application. So it should be clearly mentioned whether PRA is ready to continue that avoidance transaction application in the NCLT or he is not ready to continue. And if anything is recovered from avoidance transaction application, who will retain and how it will be distributed. वैसे तो as per IBC it is distributed as per section 53 if anything is received. But it should be mentioned in the resolution plan because ultimately there is a commercial wisdom of the COC who will decide what should be done and what should not be done. Regulation 38(3) resolution plan shall provide it address the cause of default. It should be feasible and viable. It has a provision for the effective implementation also, means you are going to implement this plan, how you are going to implement this plan. He should demonstrate the effective implementation, like monitoring committee होगी, monitoring committee में 3 member होंगे, वो plan को implement करेगी and all. That's and it has a provision for the approvals required and the timelines for the same. So this clause should be mentioned that RA may need to take the approval from the government, and in how much time he will seek the approval. There is a timeline of the 1 year in
1
which
year.
1 year from the date of the approval of the plan, he has to take the approvals required under any other law, and the resolution applicant should have
It
the
comes under
capacity.
competition. I think it should be before submitting the resolution plan to COC.
Sorry, it's not audible.
If it involves this merger or acquisition, it should be before submitting it to the COC. Approval from competition.
Yeah. It can. It in case of merger and amalgamation. And after that, there are so many approvals are required. When the resolution plan is approved, then also we need to take the so much approvals. We need to comply the other laws also, like if anything is pending in ROC side, income tax returns, financial statements, and so there are so much transactions for which we need to take the approvals from the different authorities. The resolution plan shall provide the committee may consider the requirement of a monitoring committee for the implementation of the resolution plan. So we will discuss, not discuss, it should be contained in the plan. It should have the provision in the plan. Regulation 38(5) resolution plan shall provide where the committee considers that a monitoring committee for the implementation of the resolution plan is required. Then it may, while approving the resolution plan, decide to constitute the same with the resolution professional or propose another RP or any other person as its member, provided that where the RP is proposed to be a part of the monitoring committee, the monthly fees payable to him shall not exceed the monthly fee received by him during the CIR. So if anything to be discussed here?
No, only suppose if the information memorandum is giving information about the avoidance transactions and it is communicated to the resolution applicant, and the resolution applicant, he has to factor that also in his resolution plan, whether he will pursue or he will not have any interest in future in this avoidance transaction. Suppose if he is, not taking up the avoidance transaction issues at all, then who will do that?
COC.
COC.
Because RP's office is limited at the time of approval of the resolution plan.
Okay. Yesterday also there was a discussion on this. Okay.
Section 30, submission of resolution plan by PRA. the resolution applicant may submit a resolution plan along with affidavit stating that he is eligible under section 29A to the RP prepared on the basis of the information memorandum. So, this is the section which I have not mentioned there because now we are discussing about the resolution plan. So now I am mentioning and reading this section. Section 30. A resolution applicant may submit the resolution plan along with the affidavit stating that he is eligible. 29A affidavit, it speaks about. The RP shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of the IRP cost in a manner specified by the board in priority to the payment of the other debt of the corporate debtor. So RP, as per section 53, there should be the priority payment of CIRP cost, provides for the payment of the debt then to the OC in such manner. So he will verify the plan, which shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor under section 53, or that amount that would have been paid to such creditors if the amount to be distributed under the resolution plan that had been distributed in accordance with the priority of subsection 53. So whichever is higher. So this section is talking about payment to OC, how much they should get at the time of approval of resolution plan. So this section is providing the value proposed to the OC. So this section is clarifying that at least the amount to paid to such creditors in the event of a liquidation of the corporate debtor under section 53, or the amount that would have been paid to such creditor if the distribution agar hota section 53 mein, to whichever is higher. So it is talking about priority payment to the OC first before FC. Provides for the payment of the debt to the FC who do not vote in favor of the resolution plan in such manner. So they have to be given the priority. Who have not voted means who have against voted, and which shall not be less than the amount paid to such creditors with subsection 1 of section 53 in the event of liquidation of the corporate debtor. Provides for the management of the affairs of the corporate debtor. We have already read in regulation. The plan should have the provision of the implementation and supervision of the resolution plan. Does not contravene any of the provisions for the timing. किसी और एक्ट के provisions contravene नहीं किए हुए, and conforms such other requirements. And then RP will present the COC. RP shall present to the COC for its approval such resolution plans which confirms the conditions. So if any plan we receive, but it does not conform section 32, it does not conform, like it is not providing the payment of CRP cost, it is not providing the payment to the OC, then we will not present to the COC. We can directly reject it. We can directly reject it. We need not to present to the COC as per law. We will present to COC which is compliant plan, which is fulfilling the basic condition mentioned in section 30 subsection 2. So the committee of the creditor may approve a resolution plan by vote of not less than 66% of the voting shares of the financial creditor after considering its feasibility and viability, the manner of the distribution proposed, which may take into account the order of the priority among its creditors as laid down in the subsection 1 of section 53, including the priority and value of the security interest of secured creditors as may be specified. So basically, section 30 subsection 2 is the base for submitting the plan before COC, and COC will consider all the factors which is mentioned in section 30 subsection 4. Then RA may attend the meeting. So obviously we will invite the PRA for discussion and negotiation after the approval of the COC, but he do not have any right to vote in the meeting. We will only discuss in that particular agenda, and then he will leave the meeting. The RP shall submit the plan which is approved by the COC to the adjudicating authority. So anything to be discussed?
Yeah, actually, see, arriving these figures for OC and the dissenting creditors, I think we need to first prepare a waterfall under section 53. And
we need the valuations also. We need the fair value, liquidation value first. So,
okay.
So if we are not knowing if liquidation value is nil, then nothing is necessary for OC. So we have to get the liquidation value and fair value first. Then we will prepare section 53. What is proposed to whom? How much proposed to whom? Is it falling in section 53? So we will compare the section 53 with plan offered, what is the offered, and what is to be, what should be, and what is offered. So we will compare that with provisions, and then we will discuss with COC feasibility and viability.
In the resolution plan, this resolution applicant will ask for many reliefs and concessions. So whether
I'm
they are
coming to
within
this slide. I'm coming to this slide. Because our topic is related to that. Approval of resolution plan. The prospective resolution applicant in the final list may submit the resolution plans prepared in accordance with the code. So it's very like if COC approved plan, then we will include in the final list and we will submit to the COC. So 39 PRA in the final list may submit the resolution plan prepared in accordance with this code and affidavit and all he will submit. Then regulation 39.2 submission of plan to COC. We will submit the plan to the COC. Regulation 39.3 COC will evaluate the plan and record its. This is very important. Regulation 39.3 COC shall evaluate the plan as per the evaluation matrix, which is to be annexed with RFRP. Record its deliberations on the feasibility and viability of the each resolution plan. Vote on all such resolution plans. Vote on all such resolution plans which meet the feasibility and viability. RP may discuss and facilitate. So in this meeting, when the resolution plan is going to be discussed and where the feasibility and viability is going to be discussed, so RP may discuss like that. Like he may compare the plans before the COC. He may put the comparisons of the resolution plans in the terms of tenure, in the terms of amount proposed, what is the score of the evaluation matrix, whether he is eligible, section 29 may, how much he is eligible, close by close weighting of the resolution plan. So these are the factors, whether it is feasible and viable, whether it is addressing the cause of default, whether the plan is doing the RFRP compliances or not. So we can like facilitate the COC for commercial wisdom. So we can present these parameters before the COC we are facilitating them for their better commercial wisdom. So we can propose like that. We can deliberate like that. Regulation 39.
It is bound to accept H1 plan or it can accept any plan which it is appropriate.
Which will get the highest score as per the evaluation matrix.
No, but COC has the discretion to go other than what is coming in the evaluation matrix.
No, but they approve the evaluation matrix now. With the 66% RFRP document, it is approved by the COC. They've already decided that.
That is fine. That is fine. But if, apart from that, if the COC feels otherwise, can they change that?
They need to give the reason why we are accepting this plan. Ultimately, it should be for the maximizing the interest of stakeholders. The object should be fulfilled. Why he is admitting that plan? If plan is like, if one plan is 45 crore, another plan is 40 crore, but 40 crore is giving within 30 days and 45 crore is within 6 months, then obviously COC can go for 40 crores, which is to be payable within 30 days.
The other affected parties can challenge that in the court.
Affected party can challenge, but it will not be sustainable. It is the ultimately commercial wisdom of the COC, and that's why regulation 39.3 is saying that record the deliberation on the feasibility and viability on each resolution plan. Means if we are rejecting any resolution plan, then on what basis we are rejecting, it should be monetized. So that in future, if any PR is challenging the decision of the COC, then we can show the deliberation. Actually, what happened in that meeting and why we have taken such decision. It should be supported with the legal clauses and with the legal what we have decided earlier, on what basis, whether it is fulfilling object. There are so many parameters and factors which is beyond, which go with feasibility and viability, and why the COC takes it. Ultimately, it will be for benefit of the stakeholders. COC cannot do like कि हमें फायदा हो रहा है तो हमने ऐसा decision ले लिया and all. तो it should be like record its deliberations on the feasibility and viability. Now it's up to the adjudicating authority.
The Swiss challenge method is mandatory for
not
selecting the
mandatory.
resolution plan.
No, there is a provision of the Swiss mechanism when it applies. Just a minute. I'm sharing that. Because in case of we have not mentioned in the slide, but I have done in one case. So where the so if it is generally applicable when the bidding process where a bidder makes unsolicited bid to the auctioneer. Once approved, the auctioneer then seeks the counter proposal against the original proposal and choose the best among the all option. Yeah, in one case, I remember now. In one of the case, 5 to 6 resolution plans I have received. So there was the confusion. So everybody was offering like that key COC is unable to choose what is best. So in that case, Swiss mechanism can be done. Swiss challenge mechanism can be done. And there is a provision also in the regulation.
3A, 3B. 39, 3A, 3B.
30. I have mentioned or not, I need to check. Regulation 39. Regulation 39?
B, 3B, 3B.
3B, yes. Yeah, that is tiebreaker formula.
Yeah.
3B, yeah. No, I'm talking about this type.
I think it is in PPIRP.
Sorry?
Prepackage.
No. Prepack also the same.
CIRP also it is there.
CIRP में भी है वो तो. I have done this because so there is a challenge mechanism, but actually this is applicable when there are more than like 3, 4, 5 PRAs, and I have done
It will
the
be tick size and significantly better. All this has
because
come in
yeah, in that case, but
ARP it is.
yeah, where the 2 or more resolution plans are put to vote simultaneously, and the resolution plan which receives the highest vote, but not less than requisite votes, shall be considered as approved. But however, provided that where the 2 or more resolution plan receives, if 2 or more resolution plan receives the equal votes, but not less than the requisite vote, then committee may approve any of them as per the tiebreaker formula. So it is given in regulation 39(3)(b). So we can use this formula and COC may approve this resolution plan if similar votes, similar score is given to the 2 or more resolution plans.
We'll ask them to improve it.
So it will be sort of fresh bidding from the resolution applicants.
Not needed for the fresh bidding. COC may decide.
Then everybody has a chance to improve the bid in that case.
No chance. COC, if COC do not want to give any further time, don't want to waste further time for improving the plan and all, then COC may take like there are so many parameters in the evaluation metrics on that basis COC may decide. So they can always deliberate the feasibility and viability on that parameters, because there are the 2 types of the parameters, qualitative and quantitative. So in case of quantitative parameters, they cannot adjust anywhere anything. But in case of qualitative parameters, they can take the reference of like what is the business experience, what is the net worth, what is the background of the PRA, what is the market recognition of the PRA, what is the projections of the next 5 years. So these are the factors on what basis COC can deliberate, and COC can record its deliberations upon the feasibility and viability. Because in the
They are already factored into the evaluation matrix. Qualitative factors are also considered while doing the evaluation matrix.
Because this is the only evaluation matrix is only the criteria for approving or for giving H1 bidder now. Because in case of the commercial offer, if I speak about commercial offer, your commercial and my commercial offer is same, but there may be some difference in other factors. Commercial offer may be same. You are giving offer 50 crore 30 days. I am giving offer 50 crore 30 days. But my background and your background, my manpower, your manpower, my capabilities, your capabilities may be different. And then COC may decide the feasibility and viability according to that. So I'm coming to some case laws relating to that.
So that reliefs and concessions, whether RP is supposed to reject the plan if the relief concession asks for a
yes,
beyond the scope of
my next slide is on the relief and concession. Few slides are remaining. If we discuss about the relief and concession, then I'm coming to that slide only. Just 2 minutes. Wait. This is my slide relating to relief and concession. So in the meeting where we are discussing the approval of resolution plan, obviously we will discuss the relief and concession which is claimed by PRA. So there obviously there may be the so many reliefs and concessions which will be claimed by the PRA, and as per the various judgment of the NCLT mentioned that the COC should review the reliefs and concessions before coming to us. So in the meeting itself, RP discuss the reliefs and concessions which is claimed by PRA for taking the clean slate CD. So it's a general practice, prudent practice that we just deliberate, we present what are the reliefs and concessions which is claimed, and we discuss with COC. If the COC is agreed, then we will continue it. If COC is not agreed with any particular relief and concession, then we will request the PRA to remove this relief and concession which is not reasonable and which is not going to be approved. So that depends. Yes, so discussion is necessary and it should be approved in the meeting itself. So that
many reliefs and concessions asked for from the government authorities, income tax, or the state government authorities relating to.
There may be like it's generally related to the income tax. It's generally related to the ROC, Companies Act, filing of carry forward losses related, and release of charge. Obviously, it will be done. Past liabilities, obviously, it will be done. Litigations related, interest and penalties related. So carry forward of losses related हो सकते हैं. Waiver of non-compliances, rights of OCs deemed to be waived. And these kind of the reliefs and concessions like statutory, जो भी हमारा statutory in non-compliances है, pending statutory dues है, including taxes, penalties and interest. So COC may consider, because obviously it is the in IBC he's offering, so he want to get the CD on clean slate basis. Why he will take any burden? So it should be discussed in the COC, like operational creditor settlements. So he may
for example, this write back of this whatever benefits they are getting out of waiver of loans and interest, so that will be written back as income in the books of the CD. So yes, whether the tax liability will be attracted for that, or the CD will get the relief from the NCLT.
So, no, he have to claim the relief now. So statutory dues waiver, so that I have mentioned in number 1 point, complete waiver of any pending statutory dues, including the taxes, penalties, and interest accrued up to the effective date.
That is for the past, before the commencement date of insolvency. Whatever is due, that can be asked for a waiver, but it is relating to something which is subsequent to approval of the resolution plan.
Subsequently means from the date of
approval of the resolution plan.
From the date of approval, from the effective date, the liability of SRA will be started. From the date of.
So there this write back of all the waivers and concessions from the financial creditors.
It is always mentioned in the plan that from which date my liability will be started.
No, it will be booked in the company's accounts when the balance sheet or financial statements
Obviously,
are
will
rewritten.
be, obviously,
So in
RP
that
will,
case, whether the ERA or SRA can ask for the waiver, concession on that front, that I will not pay any tax on these return back liabilities.
yes, of course, he will not pay and he will he will claim this relief and RP will prepare the last balance sheet accordingly.
Income tax authorities will agree to that.
Income tax authorities will not agree, but he will, RP need to do the needful before the effective date. There will be no responsibility of the SR. RP has to do the needful. You are talking about this period now, before effective date. And
in the
after-
resolution plan itself, the resolution applicant will ask for this waiver that I will not pay any tax on the return back liabilities, even though it is attracted after the approval of the resolution plan. So whether that is allowed by the NCLT or income tax authorities.
So you are asking from the commencement of CIRP till effective date, na?
Yeah, after the effective, because the books will be written after the resolution plan is approved. Na? So in that rewritten books, this return back liabilities will be booked as income of the CD, and on that
No,
tax
it will not
attracted.
be. It will not be booked in balance sheet. We have to clarify in the notes to accounts. We have to clarify in the notes to accounts, na? Because there can be two scenario. First, RP has a duty to complete the books of accounts till date up to the approval of resolution plan by the COC. If
No, that is fine. I'm not talking about what is to be done before the approval of the resolution plan. I'm talking
Okay,
about
after
something which
approval-
will happen after the
after-
resolution.
yes,
Approval of the resolution plan.
after approval of resolution plan, if the books are prepared, then it should be mentioned in the notes to accounts that the
You know what happens in that case, out of 100 crores liabilities, say 50 crores are written off. So those 50 crores become the income in the books of CD after the approval of the resolution plan.
No, but
Whether
SRA,
that 50 crores will attract the income tax.
yeah, but there should be the proper provisions in the notes to accounts that the company was in the CIRP and SRA was not, the company was not in the
This is
heads.
normally claimed by the SRAs in the resolution plan.
Yes.
But whether NCLT will consider that or it will leave it to the income tax authorities. If they issue the notices, then the SRA has to deal with that.
But no. But no. In NCLT also provide the reliefs to the SRA. NCLT in most of the cases provides the such kind of the relief. For the you are talking about income tax, now. So income tax
Income
reliefs are
tax.
provided by the NCLT. If we mention everything properly in the resolution plan, if we have to mention properly, we have to describe the reliefs. And it should
Normally,
be
NCLT says that whatever is permissible under the IBC, that only they will allow.
no.
Something which is beyond that, they will not get into that.
There are the few orders where the relief has been provided with respect to the taxes. Even in one of my order, it is also mentioned that last एक company की 5 से 6 साल से balance sheets भी फाइल नहीं थी ROC में, तो उसमें clearly mentioned था कि SRA is not liable to pay any additional fees or whatever the pending liabilities and all. तो वहाँ पे भी ROC की fees 6 to 7 lakhs आई थी, 6 to 7 lakhs, 10 lakhs around. So that is waived and that is done.
That is allowed before commencement of CIRP, whatever has happened, that will be within the powers of NCLT. Something
Yes.
which is beyond the approval of the resolution plan.
Yes,
Whether-
beyond the
whether they-
approval of resolution plan, there is a practical difficulties which is facing by the SRA actually. After the resolution, because there is very short period after the resolution plan by NCLT, almost in 3 to 6 months, SRA gets the handover. So in that particular day, in particular period, there is no such liability which is created in the on the part of SRA. After the approval of resolution plan by the NCLT, almost in the 6 months to maximum in 1 year, the CD is handed over to SRA. In
but the
6 months.
CD's balance sheet, which was there at the time of commencement of CIRP, that will be rewritten after the approval of the resolution plan. So after rewriting the balance sheet, there will be certain additional income seen in the books of CD,
Which income will not arise in the period of the CIRP?
Deemed income, it is there under section 241, I think, of Income Tax Act. It will be considered as a deemed income of the company, waivers and concessions which banks or financial creditors will give to the CD in the resolution fund.
During the CIRP period, there will be no income, and if there is any income you are showing in the balance sheet, it will not be taxable.
And it's the effect of approval of the resolution plan. If the resolution plan is approved, the liabilities will come down from say 100 crores to 50 crores. So those 50 crores will be reflected as income in the books of CD after the approval of the resolution plan. So how to deal with that? That is the issue.
My point is that, can I, one call, I need to attend one call, just 2 minutes, wait, we have to pause the.
The tax benefits part, if you read that, there will be.
Yeah. So जहां तक मैं आपका क्वेश्चन अंडरस्टैंड कर पाई हूँ, my understanding is you are talking there is some income which is showing in the balance sheet during the CIRP period and after the approval of resolution plan. So whether we get the tax benefit reliefs. So this is your question?
Yeah, because if the balance is restructured after the approval of the resolution plan, that impact will be reflected in the profit and loss account of the city. And
Yes.
on that, the income tax authorities may claim the tax because this becomes the income in the books of the city after the approval of resolution plan. That case.
In practical scenario, one of my case, for example, I'm giving at the time of taking the custody and control, I have to prepare the balance sheet till the insolvency commencement date. Okay.
It is not for RP, it is for the resolution applicant to deal with subsequently.
Yeah, I'm coming to that. So that time, for example, inventory, I have mentioned the inventory. I'm keeping the valuation report, and valuation report में जो भी assets है, I'm keeping it, I'm understanding that it is there. Actually, inventory is not there and it is not in condition to resell it or to get anything, but you have to pay the tax if he is showing as a assets. So we have mentioned in the balance sheet, in the recent balance sheet 23-24, we have mentioned that it is not the recoverable inventory. It is not that type of stock which we can do anything, and we are not going to pay any liability upon this. So in your case, if there is anything which is showing as an income in the balance sheet, then it will be included in the kind of past liability because it is carry forwarded from the last year to this year. during that period. So I think SRA will not have any liability and he can claim the waiver for it. So he can get the benefits, past tax benefits, including carry forward losses and all. He has to fight, he have to do fight for this because SRA is not going to pay any tax and all related to the past liabilities or past incomes and all. Because he has not earned anything from that.
There is some amendment in the Income Tax Act also to that effect. I don't recollect right now. Maybe we can proceed further.
Yeah. So if I'm directly coming to the case laws now. So our topic is what are the determinative aspects for the sanctioning of the resolution plan. Coming to that case law only. Yeah. So this is the one case law, Steel Era Engineering versus Midpoint Commodity, something like that, the case name. And I want to explain that why the resolution plan has been rejected and so we can take care about what is the actually determinative criteria for the approval of the resolution plan. So in this case, this was the COC, Midpoint Commercial and GDS schedules. There are the two financial creditors and propositions made by the resolution applicant is like that. He made the proposition to the secured FC amount was 6 crore 25 lakhs, unsecured FC this, and OC was this. So in the right hand side, I have mentioned that, just 2 minutes. So this is the position of the claims, and this is the offer made by the prospective resolution applicant. So what he offered, actually, I am just narrating, he offered that whole debt, whole claim, which is 6.49 crores, will be carried forwarded in the books of accounts of the corporate debtor. He proposed in the plan that the whole debt, he described the source of fund like that he is going to pay 6 crore 25 lakhs, may say 25 lakhs he will bring like that. 1 lakh equity, 24 lakh is the unsecured loan. And he mentioned that it is whole 6.25 crore will be carry forwarded in the balance sheet of the CD. He offered like that in the resolution plan. And then what are the defects found in the resolution plan is like that. What he mentioned, I'm just narrating that points. He mentioned in the plan that the plan validity will be up to 19th October 2023. Means he mentioned he filed the resolution plan in the month of August or September, and he mentioned that the plan is valid for only this date. So this is not a valid clause which is mentioned in the resolution plan. Next, he mentioned that if any changes is directed by the NCLT while approving the resolution plan, then would be subject to the approval of the COC. In this case, the plan is given by COC member only. In this case, the plan is given by this COC member, Midpoint Commercial. So he claimed that अगर एनसीएलटी कोई भी प्लान में चेंज करती है तो सीओसी मेंबर की, तो दिस इज डीम्ड एज अ कंडीशनल प्लान, तो एनसीएलटी रिजेक्टेड बिकॉज ही हैज मेंशन्ड दिस कंडीशन की एनसीएलटी अगर कुछ चेंज करती है देन इट विल रिक्वायर द अप्रूवल ऑफ सीओसी, तो दैट इज कंडीशनल. नॉन कंप्लायंस विद रेगुलेशन 38(2) and 38(3). तो by not addressing cause of default, so in this case NCLT mentioned that the debt is carry forwarded without any definite schedule for the repayment of the same, further non-placing of any financial projections of the corporate debtor without establishing ability to service the carry forward. So cause of default is not addressed. NCLT mentioned in the order that because the debt is carry forwarded in the books, because COC is ultimately the creditor and COC is become the RA, resolution applicant. And he is mentioning that we are acquiring this company and we are carry forwarding and we will pay this debt. But they has not mentioned how they will pay the debt. They has not mentioned They have not mentioned that how they will repay and what are the financial projections for the next 5 years, and just giving the simple statement that we are carry forwarding this debt and we will pay in the next 5 years without giving any future prospects or projections. Next, jo defects
But the
COC
surprise is that how COC has approved it without any
because
projections or anything.
The same
It is
person is the
rejected by NCLT,
yeah,
not COC.
no, COC approved the plan, and in COC RA was the COC member has given the plan.
COC only has given the plan and COC only has approved it.
Yeah, yes. So they think that COC approved, to NCLT will approve, automatically approve. They thought like that. And another defect was found that original format and revised format are having the difference in the valuation of the corporate debtor. They have filed revised format and original format. Two formats is filed, and there was a difference in the valuation of the CD. So these are the defects found by the NCLT and thereby rejected the plan. So basically, they have rejected the plan on the basis of non-addressing the cause of default. So in most of the cases, when the resolution plan consider this type of the offer, like carry forwarded the claim, then it's deemed that it is not addressing because default is continue. जो पहले था वो अभी भी है position. तो resolution plan it cannot be approved. So order finally.
Also called evergreening like that.
Sorry.
That is also like evergreening.
Yeah. So ultimately the plan has been rejected on these grounds. Next case laws is Octagon Communications Private Limited. On what basis the plan is rejected? So these are the in this case, one resolution applicant proposed 74.75 lakhs to secured financial creditor against the debt of 2.88 crores. So secured financial debt जो ICICI banks थे उसका 2.88 करोड़ का था admitted claim and he offered 74.75 lakh और इस 74.75 lakhs includes the CIRP cost. And what was the condition? कि entire debt would be converted. What was the condition in the plan? Ki entire debt would be converted into the optionally convertible debentures in the books of corporate debtor, and COC approved this plan. So he has mentioned the offer like this कि मेरा जो ये जो entire debt है इसका secured creditors का would be converted into optionally convertible debenture, and then what they mentioned. That RA proposed to pay the full amount to the operational creditor, which is showing in the balance sheet, irrespective of the claims submitted and admitted. But condition ये लगाई कि debt of the operational creditor would be converted into the OCD, optionally convertible debenture, with face value of ₹10 without the consent of operational creditor. So actually इस प्लान में ऐसा था कि वो ऐसा कर रहे थे कि जितना भी पूरा अमाउंट है वो हम पूरा कन्वर्ट कर देंगे डिबेंचर में, ऑप्शनली कन्वर्टेबल डिबेंचर means it can be converted into equity in future. So we are offering like this. तो NCLT ने what NCLT held that? तो NCLT held that फाइनेंशियल क्रेडिट COC ने अगर प्लान अप्रूव किया है कि हाँ ठीक है हम तो एग्री हैं, हमें तो आप दे दो OCD, ऑप्शनली कन्वर्टेबल डिबेंचर, वी आर एग्री, बट व्हाट अबाउट OC? So financial creditors are agreed for the conversion of the debt into OCD. That is fine. NCLT said that is fine. You agreed, but operational creditors are not agreed now, because in COC you vote, operational creditor do not vote. So they are agree or not, who will decide? So however, no approval is taken from the OC. It is said by NCLT. And it would be deemed that a default has not been addressed in the respect of OCs, which is the primary requirement of section 30 subsection 2. So OC's debt will still persist in the books of the CD. So therefore, this is the contravention of section 30 subsection 2. So and another reason for rejection of the resolution plan was CIRP period already expired हो चुका था 16th May 2024. No extension application was filed. And the application of approval of resolution plan is filed after that. Even the CIRP period is expired, you are filing the application for the approval of resolution plan. So ultimately, this plan got rejected due to this parameter. So NCLT observed that if you want to offer FC, that is fine. But if you want to offer the OCs, then you need to take the approval of operational creditors. If you want to give this kind of offer, conversion of the debt into OCD, because if I approve this plan, then the debt of the OC will still persist in the new shape, even the plan is approved. NCLT rejected this plan on this basis.
Octagon, what is that? What is the case, madam? Octagon?
Yes, case name is Octagon Communications Private Limited. I have not mentioned full name. You may search on Google, you will find out. So this is the another case law. Omkush Infrastructure Private Limited versus Merushikar Realty LLP. So in this case, RA proposed two other OCs as a nil, assuming that there is a no liquidation value. Because in this case, just CD के promoter थे वही resolution applicant थे. मतलब CD itself was the PR. So the corporate debtor was knowing that what is into the CD assets कितनी है कितनी नहीं है. तो उन्हें पता था कि they are knowing that कि there are the no assets, so liquidation value is nil. So corporate debtor was the prospective resolution applicant in this case, and so RA was not knowing anything. So RA assumed that the liquidation value is nil because there were no financial creditors and no assets as shown in the information memorandum by the RP. So resolution plan has been approved by the COC with 100% vote share. So what was the observation of the NCLT in this case? So whether it is addressing the cause of default. So in this case, what was the reason of rejection of the resolution plan is that is the wrong submission in the particular para number 26. In this case, the NCLT raised the question that whether the plan is addressing the cause of default. So what PRA was CD, and CD mentioned that. What CD mentioned? The resolution applicant submits that with the proposed settlement offered to the respective stakeholders and acquisition of control by the resolution applicant is addressing the cause of default. So this statement is not sustainable. NCLT says that this statement is not addressing the cause of default. Addressing cause of default means you have to show how much and to whom you are paying, how you are paying. So NCLT, and this is a wrong submission because in the para number 26 and form H, both are mismatching. If NCLT sees the form H, there was mentioned something else, and if we see para number 26, there was something else. So there was a difference. Therefore, NCLT clarified that cause of default has not been addressed. Next, NCLT observed another observation is that whether the plan is feasible and viable. So RA mentioned in this clause, RA mentioned that what is the feasible and viability. So RA mentioned that as already provided in the resolution plan, the profile of resolution applicant demonstrate the feasibility and viability. So this again does not address the requirement of regulation 38(3)(b). So profile लगाने से feasibility and viability prove नहीं होती है. तो NCLT says that it is not the proper submission, and RA mentioned that are also the one of the reason that कि performance guarantee is valid only till 19th July and expired as on date, and so also this is the non-compliance of regulation 36(b). So you cannot make any condition relating to the performance guarantee validation. So it will be valid. It does not have any validity period because in case of the approval of the resolution plan, by the COC, you have to give the performance guarantee, and you cannot mention this type of the clauses in the resolution plan. So this is prima facie was not valid at the time of approving this plan by the COC, so that it is rejected by the NCLT on these grounds. Also, the cause of default and feasibility viability not addressed, so the plan is totally rejected. So anything needs to be discussed then? So
Is
we have-
information memorandum, evaluation matrix, all such kind of important documents. There is no prescribed format or either devised by
No.
ICSA.
In information memorandum, there is a regulation 36 which describing what are the information which is to be mentioned.
Of course, the regular format is not there. Regulation is
Format may be different. There is no same format for the every CD or for the every RP. They can create their own format because the topic is mentioned, the particular heading is mentioned, what is to be mentioned, it is mentioned in the code.
This RP can ask the resolution applicant to make the improvement or corrections in the resolution plan before putting
Yes.
up to COC.
Yes. Obviously, when any further negotiation, modification is required, then we can communicate to the PRA to submit the revised plan, improvised
No,
plan.
before it is placed before the COC or circulated to COC, if any apparent defects are there in the plan, can RP ask the
Practically, yeah. If I say practically, what happened? When the plan is received, then I open the plan in the meeting of the COC. In the front of PRA or in the front of COC, with the approval of COC, I open the plans. In the same meeting, I discuss that the due diligence will be made by the PRA. So that is recorded in that meeting. So on that basis, we can communicate to PRA to cure that defect. Because we have to create some basis before making some legal communication. So if we will do legal communication with PRA, then we will mention that based on the plan opened in that meeting, we have made the due diligence and we have found that this defect has been identified, and we request you to please cure this defect because the plan will be tabled before the COC. And in case koi non-compliance hai, we will not be able to place this plan to the COC before COC. It is the part of that meeting only because RP under regulation 36(8) says that RP will make the due diligence of the resolution plan or the prospective
Is
resolution.
it mandatory to open the resolution plan in the COC meeting alone, or you can do it?
General practice is that it should be opened in the front of the COC member. It is not mentioned anywhere, but I think it should be opened in the because in practically though we have get the password in advance. So
it is told that every plan should be submitted to COC. It is not mentioned that it should be opened before COC because he has to scrutinize whether everything is in order.
I'm talking about general practice, practically what needs to do. That's so that the COC will do not think that it is already discussed, because ultimately the wisdom is with COC. So why we open it privately?
There will not be any objections from COC or the other PRA that
There is no objection. No, they cannot raise any objection. They
have given opportunity for improvement in the plan to some.
We have to discuss and we have to deliberate why we are rejecting and accepting the plan. That's it. Because ultimately COC will decide what is to be done, what is not to be done. They are getting the payment from the resolution plan.
You are giving opportunity to the RA to make the plan compliant by pointing out defect to him.
COC, it's a discretion of COC to cure the defect and give the opportunity to PRA.
RP on his own cannot do that.
RP with consultation with COC, because there is a particular section which says that only compliant plan जो section 30 subsection 2 में in terms with which complies 32 will be presented before COC. Will be presented before COC. If we are thinking like that, there is a small defect which can be cured, then we may discuss with COC and we may give the chance to PRA to cure the defect. We should discuss with COC. We should make the transparency. COC should have the information and knowledge that this defect has been cured by such PRA.
One member in the COC and he want to become applicant as a resolution applicant, who will vote for that in COC?
He can vote.
For himself.
Yes, it is mentioned in the regulation.
Okay.
It is mentioned in section and regulation.
There is no related party transition restriction like
In
that.
the Companies Act, it is not allowed.
Oh.
but in the IBC, it is allowed.
The interested party can vote for on his own resolution in this case.
Recently, it is done. Recently, it is done because it is mentioned in the provisions.
Because he has all the inside information in the COC.
So ultimately, NCLT is the authority now. If he is approving, then NCLT is also there.
But madam, there is a condition that the wisdom of COC will prevail. So
Wisdom of COC will prevail, but I have given the so many cases.
If it is compliant with the provisions of law, then NCLT cannot hold any objection.
Sir, that's why I have displayed some case laws before the members so that on what basis NCLT may reject. I have just discussed these cases.
The
Few cases.
commercial wisdom cannot be challenged. For other ground, it may reject.
Other ground, but it should be, the plan overall should be in conformity with the provisions overall, because sometimes COC may
Because
approve.
RP proposed the plan only once it is complied before the COC. Before that, it cannot be. The plan is complied by with the provisions of law. Second thing, commercial wisdom rested with the COC and he is the sole member of the COC, are holding more than 66% voting right. Then
Sir,
who will have him in COC?
You are correct, but everything is not mentioned in the law. Everything is not mentioned in the law because sometimes PRA makes this kind of offer which is approved by COC, but it is not addressing the cause of default in the eyes of NCLT. Because there everything and every word is not mentioned in the code. So the spirit of code, when it is not, spirit of the code is not truly determined by the COC, then it is the discretion of the NCLT whether it is addressing the cause of default or not. Because ultimately, the object of IBC is to maximize the interest of the stakeholders. If any stakeholder,
the cases which you have shown to us, I think it is as good as the assigning of the date rather than resolution.
Right.
Resolution of the plan.
The stakeholders themselves are approving that, so they are the beneficiaries, they are the losers. So
in every plan, in every matter, there can be something which up and down and which is not really consistent and for the benefit of the stakeholders, then NCLT may interrupt and reject.
I think we will get more knowledge.
Are rejected by the NCLT after more than 30 hearing and more than 4 years from submission of resolution plan. It is a factual position. Law says that it will be admitted by the NCLT within 14 days. Is there any case which has been admitted in 14 days after 2017? Law to apne jab
14 days from
the date of
Submission.
initiation has to be admitted. So basically, these are provisions in the books because Supreme Court said the discretionary power not mandatory on the part of NCLT. Everything on the part of RP is mandatory, and on the part of NCLT, it is discretionary. On the part of COC, it is discretionary. RP इतना कमजोर बच्चा उसको कोई भी पत्थर मार के जा सकता है. And he can try only, cannot again उसको झापड़ नहीं मार सकता वो. होगा NCLT में जाएगा, वो कोई बात नहीं.
Independence,
dare to become RP since
independence of RP is lost when the COC is dominating.
But I could not dare to get appointment as RP.
Ultimately, COC is getting benefit. Ultimately, COC का commercial wisdom है. They are getting the benefit. So they should have the like that strategies so that everyone will be treated fairly.
There is no
KTG.
rule and regulation for COC. They are playing as per their requirement.
Yeah, it's true, but sometimes NCLT, that's why NCLT interrupt, na? That's why NCLT interrupt when they are taking their benefit only and without seeing the benefit of the OCs, then
OC को तो बेचारे को कौन पूछता है?
पूछता कोई नहीं है, बट कुछ तो मिलना चाहिए ना, मिलता कुछ नहीं है, पर कुछ तो मिलना चाहिए ना।
मैक्सिमम टाइम तो कार्ड भी नहीं होते COC के.
So operational creditors are not worried about that because they are knowing that we are not going to get anything. They are knowing that.
ना तो शेयर होल्डर से पूछते हैं, ना ऑपरेशन क्रिएटर से पूछते हैं.
Those
That's
cases
true.
which are filed under Section 9, even in such cases also the COC is
Applicant is
playing
not part of the
mischief.
COC even. Applicant is not part of the COC in Section
That is
9.
9, yeah. And COC, they are playing dominate.
COC and RP is dominating the entire proceeding.
So the RPs should be from the NCLT panel, not proposed by the FC. Then there will be, this dependence will be low.
Yes, sir.
IP can be more independent.
Yeah, fees are paid by the COC, so
Fees
yeah,
भर रहा हूँ
dependent
मैं.
on
Let
COC
them,
only.
they have to pay the fees.
So they feel that they are paying the fee, so RP is supposed to take care of
Yeah,
their
otherwise,
interest.
this independence of the RP is very badly affected. They are working like slaves like to the COC.
That money, so RP's fee should come from some independent source, then only there will be some sanctity to the process.
nice to have discussion with all of you.
Okay, ma'am. Thank you.
Yeah.
Yes, thank you so much for active listening and participation in the session.
Okay, okay. Believing.
Thank you very much, ma'am, for taking out time and addressing the session on the topic sanctioning of the resolution plan. Thank you very much, ma'am. Ma'am, you are requested to please share the PPT referred.
Yes, ma'am, sure. May I leave the meeting, ma'am?
Yeah.
Sure, ma'am.
Yeah, okay, thank you.